Good morning, good morning, good morning, amazing Lawnerd. It's Tuesday. It's May 12th. We are just one day away from the sentencing of Kouri Richins, and they've already made the motion to continue it, and that's already been denied. So we don't have to be as worried as we were with the Banfield sentencing that it's not going to happen because, well, the motion to continue has already been denied. The state has submitted their sentencing memo. We're going to talk about that today. We have some interesting updates, I think. I hope you think so too. This is just going to do this today. I think we have some interesting updates in the Canvas hack. A lot of you are still being impacted. I can't think of anything more stressful. May is enough of a month already. And then to have, over 9,000 institutions just come screeching to a halt because of software is really quite a lot. And then I might have something for you as well in the Lawnerd shop. We'll talk about that too. Of course we will. I'm with the band tee on. Do I want to be at concerts? Yes. Am I dying that, at the sets that Dave Matthews has been playing at the opening of tour? Yes. Is my back also killing me? Yes. Do I feel incredibly torn between jumping in my car and driving to concerts and being like, but the pain is not gonna roll with that? Yes. Also, I have a ton of obligations with the graduating seniors, so I can't just run away to concerts. Though we did do that last year. I felt very bad. We booked a concert for Dr. B and my birthday, and the three of us, G opted out. The three of us went to go see Metallica. I didn't realize the concert would be the same day as the band banquet, which is a very big deal for our marching band. And so when time came around that it was like the band banquet's this day, I'm like, I am so sorry. We love the band banquet. We love y'all. We have Metallica tickets. So we are going to be celebrating band in our own way this year. We'll see you next year. Felt so bad. I felt so bad. So this year, amazing band banquet. I'm going to share in the lounge some photos from that. T was nationally recognized for his contributions into the marching arts. And I'm just like, it's almost the end of senior year. I can't do it. So what are we doing today? We got a little bit of Canvas stuff. We got a sentencing update. Emily's going to grimace as she moves her back because whoo. So we're going to do that. And we've got some Lawnerd shop stuff to talk about. Sound good? All right, Lawnerd, let's roll the intro. I've got coffee. Let me know where you're coming in from, what you're drinking / eating, because it varies depending on where in the world you are. And it's time to roll. Lawnerd, Tuesday, May 12th. We are one day away. And I am ready. But also I saw the first sentence of the state sentencing memo and I went, immediately stop reading, girl. Do you know how it is so hard? I'm getting much better at it. But it is so hard to just be like, stop reading. Because I wanted to read it all with y'all. But also, the state's coming in spicy. Right. Of course they are. Let's go. Wait, let's make sure this sounds in the right place. Let's check this in advance. Let's check it in advance. There we go. Now let's go.
Hey there, I'm lawyer and legal analyst.
Yeah, we got it right this time. Look at
this
that.
Is your go-to destination for live court
it's
coverage.
Tuesday.
I break down the law, the strategy, and the evidence in real time, so you know what's happening. No law degree required. So join the law nerds in the chat. They're here for the facts, not and let's get to court.
I know a lot of you have found the new emoji in the chat. You are welcome. I'm very excited about the new emoji in the chat. You have found lots of new things today. I'm very excited. We're going to talk about Canvas real fast. We're going to see Emily, the back is getting better, but it's a process. It's a process. It's going to be a process. Look, it's layers. So we kind of unfucked one thing and then something else was just like, oh, now I'm mad. So we're just working through it. But again, this is something that I am familiar with. Many of you are familiar with. So I am okay. It's just, it's annoying. It would be great to be fully functioning sometimes. It would be fantastic. But you'll see me just being like, it's okay. I'm okay. Thank you, law nerds. I mean, I'm not okay. I'm okay in the sense of like MCR is okay. Like I'm not okay, but I am okay. My back is fine. My emotions are a mess. It's like, how are we doing senior year? I'm like, great. I'm great. Everything's great. I'm great. It's great. It's great. Everything's great. However, with everything being great, though I am in a school district that had a bunch of swatting yesterday, which is stressful as can be, I am not also dealing with the Canvas disruption, which is helpful because at least that's something. But last time we talked about the Canvas hack, and for those of you that are like, Emily, what is the Canvas hack? For those of you that do not use this school software, it is one of the options of school software that seems to run for some schools just about everything. So exams, homework, reading assignments, communications, messaging, grades, all of the things. The hack was done by a group that calls themselves Shiny Hunters. They took responsibility for it. They had also, I think, given a lot of heads up. And the hacking group had intruded into Canvas on April 25th, 26th. Check last episode. We pulled up the dates exactly. One of those two dates. And it had not been detected by the system until the 29th, like 3 days later. So the schools had no idea that the data had been compromised. They say they took over 6 terabytes of data. That seemed low to me of the amount of data, but maybe they were only targeting certain types of data, but it was disclosed that 6 terabytes of data were taken from Canvas. The company found the hack on the 29th, tried to patch it. The hackers went, "You're adorable." And the company notified schools on May 6th that a hack had happened. And then on May 7th, we got those lockout screens that everyone saw. We shared them last week when we talked about this because the hackers were like, "Oh, you thought this was over? Girl, it's not over. We're not done." And locked out over 9,000 institutions, hundreds of millions, upwards of 250 million individuals had their data compromised because of that. So where are we now? Well, we were talking about when are the lawsuits going to start rolling? Like the yayayas, like full, like when will the lawsuits start rolling? What is the company doing? How did the company take responsibility for this? Because the notice that there had been an intrusion on their like support page on their website's not going to do it to give schools a heads up. Also, if you are in IT and you don't have a heads up about what's going on, you can't protect yourself. Can you imagine how pissed off you would be? I can imagine how pissed off you would be. Bro, I can only work with the information you give me. And if you tell us it's over, that the intrusion has been stymied and there's no need for further action, then what do? So Canvas put out this statement, and I'm very interested to see what comes of this next, because the CEO apologized, but also the CEO decided to pay the man. I don't know how many millions, but decided to pay. So let's see what they had to say. This article is from fairly late last night. It's coming from Australia's ABC News. And it was, I thought, a really thorough breakdown of what was going on. So let's pull that up and then, let's pull that up. So Canvas developer Instructure. Also, I have seen numerous people talking about this case, calling it infrastructure. I am not the only one. I feel relieved that I am not the only one. The company at the center of the cyber attack involving the details of millions of students, hundreds of millions, let's be honest. They said over 250 million individuals. Some of them are teachers and faculty. It's a lot of students. The company at the center of the cyber attack involving the details of millions of students globally this month says it has, quote, reached an agreement with the hackers. Lots of people settle in their shit this month. Everybody's like, can we get it done before Memorial Day? We're done. We're done. We're done. Almost 9,000 schools, universities, and other educational institutions were targeted in the Canvas data breach conducted by the cybercriminal group Shiny Hunters. It involved the theft of large amounts of data, including student ID numbers, email addresses, enrollment information, and messages on the learning platform. However, these platforms have access to more information than that, and I am not confident that that did not include other types of identification, addresses, social security numbers, and more. I'm not confident. Instructure, the US company that developed Canvas, has published an update to its website indicating that it has negotiated for the information not to be leaked. Okay. Quote, we understand how unsettling situations like this can be, and protecting our community remains our top priority. Maybe give the institutions a heads up before. And I understand in IT, this can be a problem. Because like all things, if you warn people too much, people eventually are like, yeah, just that again. And then they don't pay attention. But I think you have to give at least the IT departments of potentially impacted institutions the ability to make that decision. We understand how unsettling situations like this can be, and protecting our community remains our top priority, the update said. With that responsibility in mind, Instructure reached an agreement with the unauthorized actor involved in this incident. I wonder how much they paid. I really want to know how much they paid. If somebody sues them, can you please keep us in the loop on Discovery? How much did they pay? I really want to know. The company said as part of the agreement, the data has been returned along with digital confirmation of it being destroyed by the hackers. You didn't know, though, that they were in your system for numerous days. Okay. They go on to say in their release, quote, we have been informed that no Instructure customers will be extorted as a result of this incident, publicly or otherwise. However, because Shiny Hunters put out a list of the schools that were impacted, others can pretend to have this data and still attempt to extort individuals, send emails saying, hey, do this to recover your information. Hey, we're offering you free credit monitoring. Hey, we're doing this. Those schools and institutions and those that attend those schools and institutions and work there are still at risk for secondary fuckery. Truly. We have been informed. They promised. Pinky v. swear. Pinky v. promise? They pinky promised. We have been informed that no Instructure customers will be extorted as a result of this incident, publicly or otherwise. While there is never complete certainty when dealing with cyber criminals, you don't say. We believe it is important to take every step within our control to give customers additional peace of mind to the extent possible. Instructure said the agreement covered all impacted institutions and that there was no need for any individual school or university to attempt to engage with the hackers. Though we saw last week that schools have already done that. So they go on to say that the Canvas boss also apologizes for the breach. Instructor Chief Executive Steve Daly has also published a message on the company's website. They're just communicating through the website only. Surprised they didn't hack the website and put up their own statement there. But I digress. However, if you want to let us know how much they paid, I'm all ears. I'm all ears. Quote, this is the apology, by the way. Quote, over the past few days, many of you dealt with real disruption, stress on your teams, missed moments in the classroom. You don't say. You deserved more consistent communication from us, and we didn't deliver it. I'm sorry for that. Earlier communication probably would have helped too. It goes on to say that public information about the hack last week was largely limited to updates on Instructure's status page and information from the hacking group itself. Correct. It goes on to say Mr. Daly said the company made the decision to get the facts right before speaking publicly, and that it had, quote, got the balance wrong. The thing is that they knew April 29th and didn't start communicating with the schools until May 6th. That's one of the problems for me. I just don't understand why reaching out to the institutions, so at least their IT departments and their legal can start to make an appraisal and say, we are aware of an intrusion into our system. We believe that they have taken data and that they are out of the system and the system remains secure. However, you might want to keep an eye out. I don't know. Maybe. The CEO went on in his statement to say that the breach was the result of a vulnerability regarding support tickets in the service's free for teacher accounts. And that's what was exploited. I mean, that's great with the exploit and the understanding of the exploit, but what was taken, and do you really believe that you've gotten all that data back? It goes on to say that these accounts have been temporarily disabled while Instructure completes a cybersecurity review. You don't say. The CEO said core learning data, including course content, submissions, and credentials, had not been compromised. I am not as wary about course content because they did say it was only 6 terabytes of information. And if it was 9,000 plus institutions, you're going to have way more than 6 terabytes if they are also taken the course content, which is good because in the future, we're going to talk about universities that have been selling course content to train AI and the professors seeing their butchered course content showing up in different AI models. But that's not a today conversation. That's a different conversation. But if you are working at an institution where you are creating course content, it's probably time to take a look at your contract and make sure that your information is not going to be sold out from under you, because it's something that apparently you need to start asking about. So last week we shared our Incogni code. It's still on the video. It's still up and running. So if you are still interested in that, do that. If you are interested in locking down your credit so that if a social security number, yours, your child's, whoever's, you can lock those too. You can lock social security numbers of kids for their credit report so somebody can't open a credit card with their social security number. at any, you can do that with the 3 agencies or with a credit monitoring service. There are proactive actions you can take. But what I'm going to tell you is that the actions that you take regarding to this aren't just going to protect you and your information on this, because this is just one of, next one in the line hacks with information becoming available publicly. It's just, and this is going to continue to happen. To everyone working in this disruption, I am so sorry, because how stressful for you, how stressful for your students, how stressful for your teachers, how stressful for your IT departments. This sucks. And it sucks that the company was aware of it a week plus before they said anything. That's a lot of time for different IT departments to figure out how they want to address it for their own institutions. I'm a big fan of communicate more than less. This is going to shock all of you. And Cammie in the chat said, especially with finals happening. This happened because finals were happening, I suspect, because you want your breach to get attention. And the disruption of this is going to, are going to get attention. Amy, this is good to know. Amy said it's highly unlikely that social security numbers were passed to Canvas from the institution's student information system source. Me, university registrar. Amy, I'm glad to hear it. I'm glad to hear it. I hope they weren't. I also hope that if anybody's worried about it, they take action like it was, because guess what? Having that extra layer of security is going to be a good thing. And if those didn't get out on this one, fantastic. Fantastic. But I hope that they weren't. I hope that those are somewhere separate and it's not a problem. Julie, thank you for the gift of memberships. There were a few other comments about the breach that I grabbed. I know a number of you work in academia. KB said, as an IT person for a university who has worked with Canvas, most do not hold any official grades in that system, nor do they typically store social security numbers or payment information. KB, that's fantastic. Law nerds, you've heard it from 2 that work with this system. So I'm glad to hear. So thank you. Also, I saw a number of you asking about other information. We're getting to other information in just a moment. So there were a couple questions about when leaks are required to be or when breaches are required to be reported. I would have to go back and look. I am most familiar with when banks and like medical offices, shocking, are required to report a breach, but companies are required to report them. Those reporting requirements are kind of slow though. They're not immediate. I'm glad they reported it. The Canvas seemed to report it after. They were like, hey, it's fine. And then the hackers were like, hey, no, it's not. So where are we? All right. Things you can do on number one thing to deal with the most problematic part of any security breach is either get a credit monitoring service that will help locking your credit, or just reach out to all of the big 3 credit companies, TransUnion. I'm not going to remember the other 2 off my name. You guys know what I'm talking about. The chat will have your back on that. Reach out to them and just lock your credit. That means if you need to apply for a loan, a credit card, whatever, you have to go unlock it. Experian, thank you. You have to go unlock it, but you can do that through the 3 credit agencies for free. And that means no one can start a line of credit under your social security or name. You can go do that. If you've been a part of another breach and you've been notified, often they set up credit monitoring for you as a part of their settlement with those breaches. So you can reach out to Equifax, Experian, TransUnion, thank you chat, and lock your credit. And then at least no one can start lines of credit in your name and you don't have to deal with identity theft in the same way. Good? All right, law nerds. We've got a few cute things to talk about. before we talk about Kouri and all the ridiculousness. A lot of you asked last week why the Lawnard shop was locked. Well, I said we were bringing you something new. And so the Lawnard shop was locked. Pull up the something new. The Lawnard shop was locked to bring you something new. Many of you saw our Easter eggs and spoilers. I know, Emily, spoilers. It's merch. It's merch. So yeah, spoilers. If you are in the app, you would have had access to that before we started streaming, because sometimes things do sell out once we start streaming. But the Lawnard shop was locked because we wanted to bring you our I'm with the Band merch. So for this launch, we have a few fun new things for you, including this really fun tote bag that I absolutely love. I'm going to knock shirts over. Hold on. I love this so much. I love this so much, but I hope you do too. I hope you do too, because we've got our Lawnard tote with our spicy unicorn. I know, sometimes a unicorn's just pissed off. Sometimes. We've also got our rock and roll Lawnard. But it is not just a tote. The tote also comes with a removable custom strap. I annoyed everyone perfecting this strap. I am 5'6". This strap extends down like to my hip. You can look at the length of the strap on the website. It has it. It is massive. I love it so that you can accommodate however you want to wear it. But also, Emily, what are you going to be doing with this strap? This is my new clear bag strap, because all the clear bags I have, I like the bag, I hate the straps. This is my new clear bag strap. For every concert I go to this summer, you are going to see me in this Lawnard strap. I love it. Custom dyed, custom printed, custom made for the Lawnards. I cannot wait. So this strap comes with the tote that I love so much. I hit the microphone. I don't know how to explain how much I love what's next. Let me just show you real quick. We also have, if you've ever wanted to be a VIP, we also have our VIP passes. So these VIP passes, color shift. Do you want to know what this is called? Can I delight you? Because Team Baker learned this and all of us were gagged because we had no idea. Lenticular. I had no idea. That is what it's called when you can get that color shift of the facts, not fuckery. It is glorious. It is hard to show on camera, but I love it so much. This has VIP access to something I made for y'all on the back. So when you get this, you will also have VIP access to what's on the back. So that comes with your VIP badge and your Lawnard lanyard with, of course, the black clasp, because we love it. I know. And I took this with me to go to my last YouTube event. And I was like, I'm going to just use this. I'm just going to use this for my stuff because Lawnard VIP. And then they had the badges with 2 clasps. And I was like, darn it. We also, of course, have pins for those of you that are collecting the Lawnard pins. We are almost sold out of the very first pin we've launched. So, and that all the pins are limited edition. Once they're gone, they're gone. So if you do not have the full collection of pins, now is the time, because the very first pin we launched is almost gone. We also have the I'm with the Band shirt and hoodie. The I'm with the Band hoodie is our favorite. Listen to me. Listen, Lawnards. This is our favorite hoodie. This is our custom hoodie. It is the oversized drop shoulder hoodie with our custom dyed strings. Yes, these are custom dyed. No, they don't come this way. Yes, it matters to us. And I love it. The hoodies are oversized. If you like an oversized hoodie, like I'm small. If you love an oversized hoodie, get your regular size. If you do not like a big old oversized hoodie, size down. They are oversized. They have oversized. If you love a big, cozy, smushy drop shoulder, get your normal size. They are also a lighter weight hoodie. They are the same oversized hoodie. Every drop shoulder hoodie we've sold, they're the same oversized hoodie. Love, 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 love. Love, 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 love. Pigeon in the chat asked, are they dryer safe? Yes. Turn them inside out. Yes, they are. And then the question was, are they unisex? Everything we have in this launch is unisex. Yeah. And then the back has the Launard like rocker heart. I love it. I love it. This is also the hoodie with like the kangaroo pouch in the front. So these are a lighter weight hoodie, not the like heavy, heavy, smooshy, thick zip ups. I love this. That's the same thing on the back of the shirts as well. And then we have a tour tee because I want to show you the tour tee. We have a tour tee with our Rocking Launard logo on it. Yes, we print our own. Yes, we print our own tags. No tags. We hate tags. Screw the tags. No tags. We print our own tags. The Docket. So our tour shirt has the Docket on the back. We will be adding more in the future. Don't worry, we will be adding more in the future. And we've got our tour shirt with our tour list on the back. Love it, love it. Love it, love it. I hope you love it. Excuse me, I hope you love it too. We create everything for you. There was one thing that was supposed to be in this launch. One day, when I am less sad, we will talk about it in a members only live. But unfortunately, our hostile witness got held in contempt. So we're gonna have to figure out what the court needs from us so we can get hostile witness out of jail. But hostile witness got held in contempt. So unfortunately, though you saw me wearing the shirt in our podcast, that design, well, is being held up by the court at the moment. A little too hostile that witness was. However, we are not going to send anything out to you that isn't 100% ready. And unfortunately, the hostile witness was just unprepared. We'll talk about it. So I know I'm sad. I know y'all are sad. I'm so sad. I'm so sad about it. But we are working on it. Team Baker is gutted about it. I am so upset. However, I'm not sending out anything to y'all that isn't ready. And what can we expect from a hostile witness other than, well, hostile? So if you are interested in Launard merch, it is over at launardshop.com. If you had the app, you would have gotten that this morning. If you're in the Launard Lounge, you guys had a lot bit more heads up for that. You will start to see, especially those of you that were in for the exclusive early access, start to see those shipping notices. I'm very excited. So yes, the hostile witness was 100% held in contempt. Becca has thoughts. Will you ever sell the strap by itself? Not this launch. But I'm also never say never, but not this launch. This launch, it is going with the bags because it's been a minute since we have had bags and we get asked for them quite a lot. So, Launards, are we ready? Are we ready? Are we ready? Are we ready to talk Karen Reed? Not Karen Reed, other KR, Kouri Richins. Also, hold on. I needed to share. Look, we have tanks that are back. That is our unisex tank that is back. The unisex tank has a little bit of a lower sleeve on it, but we have a unisex tank that is back in our Legacy Law Nerd Love logo. So the Legacy tanks are back. You guys were asking about the tanks. We do ship outside of the US. Kim, we have been fighting with distribution on shipping rates. However, there is only so much we can do. It is something we fight about all the time and regularly and do everything we can. However, shipping rates have gotten frustrating for us. And it is one of the things when we chose not to do some of our heavier items in this merch launch was so that we could still offer things internationally, because we wanted to be able to offer them. Some things are so heavy, we just can't ship them internationally. So that's where we're at. Angela said, is it fitting that hostile witness is the problem? Yes, it is. Yes, it is. So it has been a whole bunch of things. However, we love bringing stuff to you. Every time we have an idea for a new launch, Team Baker goes above and beyond. I watch how much work they do. They go above and beyond, and I just appreciate it so much. So go check out the shop. We have some fun stuff for you. Some of our limited edition pins are almost gone. So if you want all of the pins, now's the time. So let's go. I see a lot of requests for V-necks. Lolly. The supplier that we work with for V-necks is unfortunately not very size inclusive. So we have a struggle with V-necks. We are looking for V-necks that are more size inclusive. So it is a constant balance. I hope you enjoy what we made for you. Are we ready to talk about Kouri? Let's talk about Kouri, shall we? And enjoy I'm with the band. Enjoy. A lot of you are asking, Emily, are we going to make fill in the blank? I will tell you that the team has a very long list of things we would love to make. There are balances to that because the things we make in the Law Nerd shop are custom made. And so we have balances to things. So we have a very long list of things we would love to bring forward for y'all. And we are always trying to improve that. And we are always working on the balance between custom and making sure that we can make it available, internationally, and that it is going to be great quality. So it's always an adventure. Are we ready? We got to talk about Kouri. We got to talk about sentencing, Law Nerds. We got to talk about sentencing. Should we fly to Utah? Yes. I don't know. We're going to have to take a vote about whether we just rock this version of EDB Air forever, because I love it. It makes me so happy. We might have to take a vote. There's times when there are questions on the podcast like, Emily, why haven't we covered this more? I'm like, oh, you've missed the live stream. Come to the live stream chat when we're like, hey, should we cover this more? And the live stream chat's resoundingly like, no. The chat gets to vote. Members get to vote. And chats get to vote. All right. Let's talk Kouri Richins. Kouri Richins is scheduled to be sentenced in Utah tomorrow. The pre-sentence investigation report has been filed. I have not seen a sentencing memo filed for the defense. I'm going to check. I'll get the docket pulling up now because I did not see any response from the defense. But remember, they had said they wanted more time for sentencing, and the judge denied that. Well, the judge denied continuing the case. The judge gave them more time for sentencing. This sentencing had originally been scheduled for the afternoon. The sentencing is starting tomorrow at 9:30 a.m. Mountain. We will be starting at 10:45 a.m. Central. Why? Well, there will probably be a break in the day at lunch. There will be, well, I am giving room to make sure that our court feed as part of the pool is up and running smoothly and has audio and all of the things. And I am wanting to give us just that little bit of wiggle room. So that will roll earlier than our normal stream and will probably be, well, they are accommodating for it to be most of the day. I don't know if it actually will be most of the day. The defense needed a full day. Are they going to use it, chat? Is the defense going to use the full day? Or are they going to not take a lunch break, go from 9:30 to maybe 1 and then be done? I guess we'll see tomorrow, because the defense had said they needed time, they needed witnesses, and maybe they do. And maybe we'll see that. And maybe we'll see a statement from Kouri. I will be keeping you in the loop when the impact statements are over. Let me tell you what I'll be keeping you in the loop on. And Miguelina, we might want to let the app know that we've moved on to sentencing as well, just in case, or moved on to talking about Kouri's sentencing. Oh, the court filed an amended decorum order this morning. No filing from the defense. So what's the decorum order going to be? We'll take a look, because the court filed this morning. So we've got that now too. But tomorrow we will let you know when court gets, well, when I start streaming, when court gets rolling. If there's a gap in time, there probably won't be. When impact statements begin, when impact statements are over. If you are doing something tomorrow where crying is not comfortable for you, well, getting your hair cut, but then again, my hairstylist is also a therapist, as they so often are, so that would be fine for me. If you are at the dentist, if you are at work, if you are at meetings, if you are teaching, proctoring exams, what have you, tomorrow's not the day. And then I think the order that we will see this in is the state's impact statements, the defense. Well, there will probably be motions. There will probably be a defense saying one thing. Can we do one thing? Then there will be impact statements from the state, impact statement from Kouri, then argument, then sentencing. That's what I am guessing we will see the order tomorrow. And in the app, I will just keep you in the loop. So if you want to just jump in for the attorneys making arguments, the judge sentencing, you have the option to jump in then. That's the goal. So that is the goal. So let's see what the state had to say. I just want to make sure, let me move it. I want to make sure I keep the court's new decorum order where I can find it. So let me go put that where I can find it so that I don't forget. Should we do it first? If we do it first, then I definitely won't forget. Let's just do the new decorum order first real quick. And then I definitely can't forget, and we'll just be done with it. And then we'll go to the sentencing memo, because we'll just scoot through this. And then before we finish streaming today, because I'm going to try to get my back feeling better, because I think tomorrow's going to be a pretty full day, I will double check and see if the defense filed anything. If the defense files anything at any point today, I'll let you know in the app. I'll let you know in the app. I'm not going to wait to see if the defense files something at the end of the day. I'm surprised that they haven't at this point, but how surprised can we be? All right. Emily Fights with Technology, Part 7. No, it's getting better though. I swear. This has gotten much better. We're doing this faster. Look at this. It's like we've got it sorted out. Love it. This was filed by the court this morning. Let's see if we can figure out together who the court thinks needed this information. We're just going to guess. Fourth amended decorum order. It's not you. It's the document was just, jumping. The law not only allows, but compels the courts to ensure that judicial proceedings are conducted in an orderly, solemn environment, free from the interferences which so often accompany modern news coverage of the events. Oh boy. There will be no fuckery in this court. Do you note the year of that quote? 1970. The year of the quote, 1970. There will be no fuckery. There will be no wailing. There will be no yelling. There will be no hysterics. Under Utah Code 78A-2-201 and the UCJA rules 4-401.01 et sec, the court enters the following decorum order to establish standards of conduct for those attending trial and subsequent hearings in this case. The objectives of this order are to protect the parties' right to a fair and impartial hearing, protect against unfair prejudice to the parties, permit the public access to legal proceedings. I don't think there's any public seats tomorrow. I think there are friends and family seats and media seats, and that's it. I don't think there are any public seats tomorrow. If you are in Utah and you wanted to go to court and watch this happen tomorrow, if you are allowed in the courtroom, then you will be in the overflow room because there are no seats for the public in court tomorrow. So just come watch with us. Because honestly, then you can see the parties' faces instead of the backs of their heads. To allow for electronic media coverage of the legal proceedings and ensure the orderly and efficient management of the legal proceedings. Oh, keep reading, Emily. There we go. Keep reading. Keep reading. Courtroom seating. Courtroom B has limited seating. The number of spectators shall not exceed courtroom capacity. The defendant, counsel of record, and the counsel support staff may sit in the front of the bar. All other spectators must sit behind the bar, separating the wall from the gallery. Beginning May 11th, 2026, and until further order of the court, seating of spectators during proceedings in this matter shall be as follows. We saw the court say this at the end of the verdict. This was decided then. The first and second rows of the gallery, this seating is limited to 12 spots per row. On odd numbered days, the first and second rows of the gallery shall be reserved for Eric Richins' friends and family. On even numbered days, for Kouri Richins' friends and family. Remember, tomorrow, May 13th, is also Eric Richins' birthday. And his family will be in the first and second rows on the 13th. Third row of the gallery. The third row of the gallery is reserved for up to 12 media representatives who have prior approval. They've already made that list. I think they've given out 10 of those, and that's the entire courtroom. Fourth and fifth rows of the gallery is limited to 12 spots per row. On even numbered days, the fourth and fifth row shall be reserved for Kouri Richins. On even numbered days, the fourth and fifth row for Eric Richins. 24 wristbands for Kouri Richins' friends and family will be provided to Kathy Nestor. 24 wristbands for Eric Richins' family. Spectators interested in receiving a wristband must coordinate with the attorneys or witness impact. If you do not already know them, that is not for you. They have reserved the right side of the courtroom for the pool camera. The pool camera for this trial had been Court TV. Court TV was purchased by Law and Crime, so it's now Law and Crime. Court personnel, including but not limited to court bailiffs, are authorized to manage which people are permitted to sit. And then it says conduct of spectators. Be quiet, be respectful, no yelling, no shouting, no hollering, no pins, buttons, signs, clothing, photographs expressing support for or against any person in this case. They will be allowed to have photos of the victim in court during the prosecution's statement. Those things can be given to the judge, but they don't want somebody rolling in at trial with like a Kouri did it t-shirt. This goes on to talk about parking lot access and additional orders to news reporters. These are the same that they were previously, updating that the pool camera is now law and crime because it was Court TV. And again, Court TV was purchased. And then they've got the whole decorum order on where the cameras will be. We will have access to that tomorrow. So this was signed yesterday, filed today. Let's take a look at the sentencing memorandum from the prosecution. So what changed for the decorum order? A clearer delineation of who's sitting where, updating who the pool camera access is, and that's about it. Reminding everyone that it will be an orderly courtroom, and that is the expectation. There is no seating for the public for sentencing tomorrow. All right, are we ready? Let's swoop. Let's get to the state's sentencing memorandum. They filed this yesterday. Haven't seen one from the defense yet. Don't know if we will. Remember, the defense had argued they needed to continue this sentencing date, and the state came back and said, you don't need to continue the sentencing date. Kouri was on the phone with her aunt saying, oh, I told Kathy Nestor to continue it, and she said that she would. Well, the court said that she wouldn't. So the court, instead of giving them a half day, has given them a full day to accommodate for the defense's presentation of evidence at sentencing. And we don't have a sentencing memorandum from them yet. All right. Are we ready? Let's get dangerous. Let's get dangerous. Let's get into this sentencing memorandum from the state. State's sentencing memorandum. Again, this was filed yesterday, Monday, May 11th. Sentencing is scheduled for Wednesday, May 13th. I will be streaming that live with you. On Valentine's Day 2022, Kouri Richins tried and failed to murder her husband and the father of her 3 young children. And at that moment, I went, oh shit. Stop, Emily, stop reading. We're going to just cover this tomorrow. Put this one down. We're going to cover this tomorrow with the law nerds. That is an oh shit beginning of a sentence for me. Oh shit. Oh shit. Indeed. I'm going to just read that one more time. On Valentine's Day 2022, Kouri Richins tried and failed to murder her husband and the father of her 3 young children, Eric Richins. Over the next 17 days, she did not think, quote, what have I done? Rather, she thought, how can I do better? Damn. She girl bossed that a little bit harder. And then she murdered Eric in the presence of their children using poison and for money. Such a person should never again lurk among the rest of us. Holy spicy Bloodworth. Her children should never worry that they may one day encounter her. Accordingly, the state requests that the court impose a sentence of life in prison without parole. Kouri Richins has earned it. Her children deserve it. Only this court can order it. Well, I will tell you for certain, law nerds, many things in what we cover are not certain. I can tell you this for 100% fact. I have never written a sentencing memo this good. I have never written a sentencing memo this good. I have never written a sentencing memo this good. And I am now disappointed in myself. Damn it. It's so good. It's so good. The prosecution's like, mention it all. What are the options for the court tomorrow? Let's talk about that real quick. The options for the court tomorrow, and there are options. This could be a 25 to life case, which gives Kouri Richins the opportunity to be released from prison in the future. Or life without the possibility of parole. It is clear to me that the state is asking for life without the possibility of parole. I think this is a case where life without the possibility of parole is very, very much on the table. It's the attempted murder, then the murder, and then the special circ murder that gives the court the grounds to do that. The special circumstance murder gives the court those grounds. They will also call it aggravated murder. I will use the two and continue to use the two synonymously. So, the court has the option. I don't disagree with the state. I don't think Kouri Richins has shown remorse. I don't think Kouri Richins has shown reflection. I don't think Kouri Richins showed that she was inclined to stop short of murdering Eric Richins. The evidence in this trial indicated to me that Kouri was going to do what Kouri was going to do. And it's not just this. And it's not just Eric. It's also Chelsea Barney. It's also all of the financial crimes. Kouri has shown with her behavior that Kouri's going to do what Kouri's going to do to get what she wants. And how those that get in her way will be treated really depends on how in her way they are and their relative usefulness to her. And when she deems that somebody's relative usefulness no longer outweighs how much they are in her way, she has shown that she will not hesitate to kill someone. This is a calculated, chilling, planned, premeditated, about as much premeditation as I think we've ever seen, premeditated murder. And when Eric Richins didn't die on Valentine's Day, she didn't want to figure out what made him so sick. If he was going to go to the doctor and try to follow up on what could have possibly made him so ill. That's not what she did. She reached back out to Carmen Lauber and asked for something stronger. That's an LWOP case to me, if they are not seeking it as more. That's an LWOP case to me. For those of you asking, just a quick reminder, when we talk about special circumstances murder, aggravated murder, I use those two things interchangeably. That is that murder plus, where you have a murder and then there is a plus element, an aggravated or a special circumstance that takes it from a first-degree murder into aggravated or special circumstance murder. In this case, the jury found that the plus, that the aggravators, that the special circumstances were pecuniary gain and poison. We have seen that charged in the David case as lying in wait, pecuniary gain, or for financial gain. We have seen that charged in the Reiner case as financial gain and multiple murder. We saw that in the Brandon Banfield case as multiple murder. So more than one victim. So we've seen them in different cases expressed different ways. So I think LWOP is appropriate. LWOP is life without possibility of parole. I mean, I guess technically, chat, and let me know if I'm correct in this, life without the possibility of parole, it seems like the end of that should be OPP. I'm just saying. It seems like we should be spelling it LWOPP. It's all right with me. I am definitely down with that kind of OPP. Let's go. I have no problem. Kouri Richins can hang out with Banfield under the jail. She might be the only defendant we've seen that's actually not taller than Banfield. Continuing on. The state's sentencing request. Count 1, aggravated murder. The court should order the defendant serve life in prison without the possibility of parole. Look. Life without the possibility of parole. There's an OPP there. Look, if without can be abbreviated as a W and an O, we can use possibility of parole. Attempted aggravated murder. The court should order the defendant serve 5 years to life in prison consecutive to any other sentence. Consecutive means after. Consec. Also, the fact that attempted aggravated murder has a floor of 5 years is fucking insane. It's insane. How are we not at least at like 15? What? 5? 5 is wild. Count 3, insurance fraud. The court should order the defendant to serve 1 to 15 years in prison consecutive to any other sentence. So it would add. Count 4, insurance fraud. The court should order the defendant to serve 1 to 15 years in prison consecutive to any other sentence. Count 5, forgery. The court should order the defendant to serve 1 to 5 years in prison consecutive to any other sentence. So Utah, give me 2. Utah's sentencing makes my head hurt. Utah's sentencing makes my head hurt a little bit. It really does. Utah's sentencing is open-ended for the prison parole board to determine. So when you see that range of 1 to 15 years, the court can't say it's 15, bye-bye. The court can basically sentence her to 1 to 15 consecutive, and then the prison gets to decide if it's 1, 2, up to 15. And so those floors are the minimum. The top number is the maximum. The defendant gets sentenced. If this was just an insurance fraud count, she could be sentenced basically to 1 to 15 years, and then the prison would decide. But here, it will matter most if on count 1, she gets 25 to life, and then the other things get added consecutive. Because then you would have to serve 25, then you would have to serve 5, then you would have to start serving the 1 to 15, then the 1 to 15, and onward. So it's hard to really apportion how many years it would be. In California, you could just calculate this out. But in Utah, there's that range that does not become more final. So what she's looking at truly is the difference between 25 to life plus and life without the possibility of parole plus whatever, it's still LWOP. So if she gets an LWOP sentence, it will be LWOP plus 5 to life, which means if they decide she never gets out, she never gets out on the 5 to life. But 25 to life plus 5 to life, you would then 30 to life, and then plus the others, plus 1, plus 1, plus 1. And then all of those plus ones have a range, 1 to 15 or 1 to 5. Hopefully that makes sense. It is odd to me that the judges can't give a floor of their own. I don't know if maybe with the insurance fraud they can. In other jurisdictions, when there's a range of like 1 to 15, the judge could say, you're getting 10. Period. Here, they always get that range. And it is a different way of doing things. If she gets LWOP, it's not going to matter as much. If she gets 25 to life, it matters a little bit more. So if she's in that 25 to life range, then you have to add up the bottom numbers to the top numbers, which would become 25 plus 5 plus 3. And then that range would be 30 whatever to life plus life. Well, it would technically be, I guess, 33 years to whatever the top number is with the 15 plus 15 plus 5. So it'd be that range to life. She wants the determinant 25 to life sentence, not the LWOP. That's what she's going to argue for. But there's more here. We're not done yet. And I agree. Northwest NW said she could be out at like 57. Yes. Yes. It's, I would be surprised if the court does not do LWOP plus 5, what is that? 6, 7, 8 plus 8 to life, or 8 to 30 to life. Dorito Dust said, does any other state sentence this way? Not that we've seen. I haven't seen anyone else do their indeterminate sentencings quite this way. I would imagine it's not just stressful for family members, because there's something to be said when it's like, okay, this person's getting sentenced to this amount of years. But I imagine it also can be stressful for defendants because they don't quite know how long they're in for. However, it does incentivize good behavior a lot, because the more they rehabilitate in custody, they can actually earn an earlier release different than it's earned in other states. But the sentencing is strange. We talked about this a lot in the Ruby Frankie case. The sentencing is strange. To me, it's just a different way to do it. I think the judges that know the case have the opportunity to, or should have the opportunity to, give their input. That said, we have seen some wild judges on this channel, not in Utah, but we have seen some wild judges on this channel. So maybe you don't want every judge having that power. It's up to the voters in the state, and it's up to the legislature. If they want to change it, they can. If it's working for them, they don't have to. Moving on. The court should enter a continuous protective order in favor of Eric Richins' family members that prohibits the defendant from contacting them unless they first initiate contact. And prohibits her from maintaining or benefiting from the insurance on the lives of the children. And then they list out all of the family members. Right. Remember, Kouri has lost her parental rights of the children already. And everybody's going to ask where the children are. They're with the Richins family. I'm not going to get into that more. I think it is for the benefit of the children that everybody's just leaves it at they are with the Richins family, because it's going to be hard enough. They go on to ask for restitution. Look at this. The court should order the defendant to pay restitution to auto owners insurance company in the amount of $1,017,018.49, and True Stage Insurance Company in the amount of $352,562.61. Do you think the defense is going to argue that they need this to be set over for a separate restitution hearing? Probably. Let's see if there's any more restitution in this. There is. The court should order the defendant to pay recoupment to Summit County in the amount of $1,391,943.98. They're definitely going to ask for a restitution hearing. If they're entitled to it, I don't know if they are. Florida does this too. Florida's like, we've prosecuted you, now pay us back for prosecuting you. And there are jurisdictions that can do this. We've had to prosecute you. We've spent over $1.3 million to prosecute you. Pay us for prosecuting you. Don't crime at us. $1.3 million to pay for the prosecution. But you know what? That's not even including the cost of her attorneys, which Summit County also paid. Because the cost of her attorneys, I think, was upwards of $2 million by the end. Because when they had run out of fees, they had asked for another $1 million. I think this is exclusive of her defense fees. I think you would add $2 million to this to include the cost of defense attorneys. That would be my supposition, but I guess we'll hear tomorrow. Maybe. Argument. When sentencing, the court is to weigh and consider public safety, punishment, deterrence, incapacitation, restitution, and rehabilitation. Has Kouri shown any indication that she is amenable to rehabilitation? I mean, we know she's not amenable to restitution. She broke. She broke. Continuing on. For consecutive versus concurrent sentencing decisions, the court must consider, quote, the gravity and the circumstance of the offenses, the number of victims, and the history, character, and rehabilitative needs of the defendant. A sentence in a criminal case should be appropriate for the defendant in light of their background and the crime committed, and also serve the interests of society which underlie the criminal justice system. There's a consideration for both. There's a consideration for both here. The court is to examine both aggravating and mitigating factors. Aggravating factors meaning things that take you from what the lower end of the sentence is up. Mitigating factors, things that take you from what the sentence is down. And because there's a difference between, a substantial one, between life without the possibility of parole and 25 to life, because there is a big difference, or is it 15 to life? I think it's 25 to life. There's a big difference there for the defendant. And so I imagine we'll see a fight from the defense, though I'm surprised not a sentencing memo. I wonder if the PSR, the pre-sentencing report, I wonder if the PSR also recommended OWOP. It's private. We don't normally see those. We'll probably hear about it tomorrow in argument. Maybe we'll see it in this. I have not read the rest of the brief, so I don't know. I saw the spiciness at the beginning and I went, pause. Pausing immediately. All right. The court is to examine both aggravating and mitigating factors to include the nature and circumstances of the crime, the defendant's character, background, history, mental and physical condition, the impact of the crime on the victim's family and community, and any other factors in aggravation or mitigation of the penalty. Not all aggravating and mitigating factors are equally important, and one factor in mitigation or aggravation may weigh more than several factors on the opposite side. The attempt and then the murder is going to weigh heavily. Diana says, what happens if she can't pay restitution? Then they don't get restitution. I don't know if there's a lot of civil lawsuits ongoing. I don't think there's much left. They're fighting over what's left, but there's not much left. Paige said, is her book for sale? No, her book has been yeeted off of the internet. Could they do something where restitution is linked to future profits? Yes, restitution can be linked to any future money she earns. It can. But here's what we see a lot of defendants do, is if photos of her or photos that she took are used, media outlets that pay for those photos, because they don't pay for interviews, they pay for the licensing of the photos and such, that would probably get paid to her mother. it wouldn't get paid directly to her. So it would sidestep whether it can be gotten from her. But if money is on their books, if people put a lot of money on her books, we saw this in a number of cases. The first one that comes to mind is R. Kelly, where a restitution hold was put on his books. But if a lot of money is put on her books, you can get restitution out of that as well. They go on to say that a few egregious aggravating factors may outweigh several mitigating circumstances claimed by a defendant. The psychological reality is that what case is this coming from? State v. Holland? The quote, psychological reality is that aggravating circumstances in the first-degree murder cases will virtually always outweigh or be more compelling than the mitigating circumstances, because the commission of a capital homicide, i.e. an intentional murder, is one of the most heinous acts known to society. These aren't accidental deaths. You don't get to a capital murder, an aggravated or special circumstances murder, without there being more than just someone died. The sheer emotional impact of all the evidence of an unjustified killing tends to overwhelm evidence of mitigating factors in the mind of a sentencing authority. The court is to consider the totality of the circumstances in imposing sentence that is proportionate to the crime and the culpability of the defendant. How culpable is the defendant? Also, that is Dr. B. If it sounds like there is work happening, that is Dr. B. That is Dr. B outside. We are leveling something in the garden because it annoyed both of us. So if you hear that in the background, it is not you. It is at my house. Sorry. It's just one of those days when we have a countdown to people coming to our house. So the court is to consider the totality of the circumstances in imposing a sentence that is proportionate to the crime and the culpability of the defendant. The court is not limited to the circumstances of the crimes for which the defendant has been convicted, but may consider other factors as well. Evidence that is inadmissible at the guilt stage may be admissible for the purpose of sentencing. And we've seen that in a number of cases, but you also see that most clearly when the guilt phase and the sentencing phase are separated out, which you often see in DP cases, right? You'll see that the jury has to make the decision between LWOP and death, and there will be a separate part of the trial for that because the information that can come in at sentencing is not the same as the information that can come in at the guilt phase. Remember, we talked about this really, really, really acutely in this case. The throat punching the sister-in-law doesn't come in at trial. It is one of those pieces of evidence that is not more probative than prejudicial. It's more prejudicial than probative. It makes you go, who the fuck does that? More than it makes you or helps you determine who committed the homicide in this case. That's why that information didn't come in at the trial, but can come in at sentencing. The way that Kouri behaved can come in at sentencing. I think it's one of our best examples of more prejudicial than probative because it's the type of information that makes you just look at a person and go, oh, fuck this shit. But it doesn't help you figure out if she's guilty or not. So we've talked about that a lot, especially when we went back and looked at the bail hearing. There were things in the bail hearing I had completely forgotten about, including the golf tournament that the family was excluded from, the money taken from the golf tournament, and what have you. There's a lot of information in this case that can come in at sentencing. Okay, continuing on. So the prosecution's laying the groundwork for, it seems, what might come in at sentencing. They say here the state took the death penalty off the table in the early days of this case with their notice of intent not to seek DP. Accordingly, on count one, the court must sentence the defendant to either LWOP or an indeterminate term of 25 to life. Indeterminate means after 25, it's like, meh. MST 3K Harris said golf tournament. Yes, We will link below where I covered the bond hearing for the second time after trial. Long and short, Kouri threw a golf tournament on Eric Richins' 40th birthday, and all the money went directly into one of her bank accounts, and his family was not invited. It was like a memorial charity tournament, and she pocketed the money, and his family wasn't invited. And she did it on his birthday. It's a deep cut. You're welcome. I figure if you guys are asking questions, more people in the chat have them. So when I see one, I figure there are more. And she did it on his birthday. And now she's getting sentenced on his birthday. Sometimes the universe has a funny way of working things out. So, continuing on. They go on to say, there is no presumption in favor of either of the two sentencing options. What Bloodworth is saying is simply that under the law, there is not a presumption that you get one over the other. In some cases, there is a presumption that the sentence would be X or Y, and then the defense has to overcome that presumption with some type of evidence that is strong enough to overcome that presumption. Here it's neutral. So the scales are equal, and then the aggravating mitigating shifts those scales in the court's mind. They go on to say, in totality, the egregious aggravators outweigh the perfunctory mitigators. Love Bloodworth's writing. The perfunctory mitigators and require a sentence of life without parole on count 1 and consecutive sentencing on the remaining counts. Consecutive sentencing on the remaining counts is a note of how the court feels about it. So it is a and this, and this, and this, and this. The court should sentence the defendant to life without parole on count 1. The nature and circumstances of the crime are irrational. All right. Continuing on with the state's sentencing memorandum. The defendant murdered her husband in the presence of their young children using a poison for money, and after trying and failing to murder him 17 days earlier. The Utah legislature recognizes that homicidal poisoning and murdering for money are each so heinous as to individually warrant the death penalty. Here, the jury found the defendant guilty of both aggravators. The defendant chose poison. I am fighting to not just start singing Tool right now. That is a deep, deep cut. If you know what I am referencing, drop the song title in the chat. My brain does in fact operate by playlist, but I am struggling to not just start singing Tool, or at least I think it's kind of a deep cut. Maybe it's not. You guys put it in the chat. Continuing on. The defendant chose poison. Jurists throughout time have recognized the particularly heinous nature of homicidal poisoning. Of all species of death, the most detestable is that of poison. Thank you. I saw it for the first one. A Forrest, you're the first one I saw. Put it in the chat. Ding, ding, ding. Ding, ding, ding. Yep. Also, I have thoughts about this. We will shuffle a different day on my thoughts about all of this. But quoting William Blackstone from 1769, of all species of death, the most detestable is that of poison, because it can, of all others, be the least prevented either by manhood or forethought. 1769. You can't see it coming. There's nothing you can do. The Florida Supreme Court has called poisoning a conscienceless, pitiless crime. They go on to say, from the California Supreme Court, People v. Brown, this is from 2023. We've moved from 1769 to 1988 to 2023. We have gotten through an entire law treatise. The California Supreme Court observed a murder carried out by deliberately giving the victim poison is more cruel and aggravated than other malicious or intentional killings, both because such a killing involves preparation and planning, and because the killer intentionally deprives the victim of any chance of escape or self-defense. They go on to quote from that case that the poisoner acts surreptitiously, thus avoiding detection, often betraying the most intimate trust. And that is part of it. Here, the defendant betrayed the most intimate trust of her husband and her children. The defendant decided that Eric Richins' money was worth more than his life. Courts have consistently recognized that spousal murders motivated by money are especially egregious. Remember, there is a aggravator. I think it's a time aggravator for domestic violence related killings, and the jury was not asked to determine that. The defense stipulated. Will the defense argue that tomorrow? I hope not. Probably not. Why would they do that? They stipulated. But I haven't seen that come up yet in this sentencing memo that they stipulated to that. But the court is aware that this is a domestic violence related homicide. They go on to say that the Arizona Supreme Court observed, quote, the killing in this case, when they say this, they are referring to the case in Arizona State v. Wallaby, I don't know. That one from Arizona in 1995. They are quoting, for those of you listening in the background, when we say this case, we're not talking about the Richins case, we're talking about the underlying case law case. Thank you. The Arizona Supreme Court observed, quote, the killing in this case did not arise out of a heat of passion, fear, struggle, or attempt to escape. The killing was not the result of a momentary premeditation, but of the defendant's deliberate, careful, conceived, meticulously planned, and cold-blooded scheme to kill rather than divorce his unsuspecting wife. Well, some things are fairly similar, which is why we see the prosecution quoting it here. Similar to Banfield. Banfield is about as cold-blooded, premeditated, and planned as we've ever seen. Different, and we've talked about Sarah Boone a lot lately, different than Sarah Boone. When Sarah Boone zipped her victim, Jorge Torres, into the suitcase, it is my perspective that Sarah Boone was indifferent to whether or not he died. If he died, If he lived, indifferent to him dying. But not taking those premeditated steps to kill him. And that's why that was charged as a second degree. And she kept saying, well, it's not intentional. Yeah, but you didn't care. This case in Banfield had a level of premeditated planning that is calculated and chilling. The prosecution goes on to cite State v. Chu. I've got that one from 1994. The New Jersey Supreme Court observed, quote, these killings do not stem from some powerful, visceral emotion, but rather from greed and expedience. That is a great quote. Because as I said at the top of this, it seemed that Kouri balanced in her mind whether the victim's benefit to her or how much the victim was in her way of what she wanted balanced. And once she got to the, you're not as beneficial to me as you are in my way, the scales tipped. They go on to quote from that New Jersey case, furthermore, few crimes display a more callous disregard for human life than the premeditated decision to seek profit by way of homicide. It evidences an abandonment of all of the rules that society has constructed to maintain communal life and warrants the fullest condemnation and retribution. We're at full may it weigh heavy on your soul. We've gone full Judge A with that. Warrants the fullest condemnation and retribution. There was a murder for hire case in the courthouse where I was working that I watched parts of. The DA was fantastic in that case. It is a chilling and heartbreaking case. By the time it got to sentencing, one of the more even-tempered judges at that courthouse. It was a spicy courthouse. The bench was feisty. This was the why don't you get on a stool and fight me courthouse. That courthouse. This is the same courthouse. But the judge in sentencing one of the defendants, because this went through multiple trials like the Adelson case, because murder for hire, looked at the defendant and started to talk about how long he had been on the bench, how many cases he had seen, how many gang cases he had seen, how many murders he had seen, and said that this case is one of the most horrific and chilling that he had ever seen, and that there is no hope for rehabilitation with someone, I believe he said, whose soul is so depraved. And I was like, damn. It was damn. Felt the same way when Judge A was like, may it weigh heavy on your soul. Damn. And I don't think that Judge A is that type of judge. I don't think Judge A is that type of judge, but it was one of those moments. I was sitting in sentencing and I was like, holy shit. Then again, the Law Nerd Chat and I are, panicky if we think we might not have done the thing we were supposed to do, and then we beat ourselves up over it. The way we would feel in that circumstance, well, is not this. We would not be in that circumstance. The Law Nerds voted most likely to have to pay a tax because you've registered your vehicle late, but not all of this. But damn, I am very, very curious to see how Judge A navigates it, because Judge M, I was surprised that Judge A brought as much smoke as she did. I was like, who knew? So maybe we will see a different side of Judge M as well. Hippler also, yes, there were things that Hippler said in his sentencing that I tried to tell Judge Abby. I was like, dude, this judge, loved what he had to say. There are still things from that sentencing. If I try to retell that, I will start to cry because it was so visceral. Also, it was about your kids going to college. And I was just like, holy shit. That puts you guys know what he said. It does it differently. Continuing on. The impact on the victim's family is irreparable. Irreparable? One of those pronunciations I'm sure is correct. Damn it. I'm going to try to read this. I'm going to try to voice the things that are in the memo, but it is also on the screen. It starts with, fathers are not meant to bury sons. And it starts that way because Eric Richins' mother is predeceased. This is not a slight to Eric Richins' mom, for those of you just coming in. It's not a slight to Eric's mother. Eric's mother is predeceased. Or predeceased Eric. That's a very legal word. Has already passed. Nope. Damn it, Bloodworth. I agree, but it's May. Oh, we can't. We can't talk about it. We don't talk about Bruno. Bloodworth goes on to say that losing a sibling is losing a piece of yourself. But there are no greater victims in this case than Eric's 3 young boys. Agreed. The defendant took both of their parents from them. Agreed. The aggravated murder was a crime of domestic violence in the presence of children. Eric Richins was a good husband. He cared and provided for his wife and even protected her from herself. Eric was a good father. He knew the defendant tried to murder him on Valentine's Day. And he also knew that it was unsafe for his children if he were to leave the home. Eric died protecting his boys, and they knew it. And they knew it? Oh, there's more. Oh, boy. Okay, everybody. I did not pre-read the sentencing memo. But as we get into the next part, we are going to be talking about things that the children have said. If you are not in a place where that is going to put you in the feels, it is okay to nope out now. This will all be timestamped. Wow. Eric died protecting his boys, and they know it. CR was 9 years old when his mother murdered his father. He is now 13 and wears his father's clothes to school. Right. I'm breathing. We're breathing. We're breathing. We're all breathing. Because we knew. Because we knew. We knew the cost of this. But it hasn't really been said out loud. We've talked about the cost of this. I think I've said repeatedly that I hope that the kids know less, but they're kids. Kids know. Kids also pick up on energy. They know. It goes on to say that following Eric's death, DCFS supported a finding of emotional and physical abuse by the defendant against CR. Sentencing Exhibit A. We do not have Exhibit A. We're not going to go through Exhibit A. But the kids were in the home. He and his brothers have participated in intense therapy since the defendant was arrested 3 years ago. Good. I'm so glad to hear it. It's not going to undone. It's not going to undone. It's not going to undo what they lived through. But I really, really hope that through starting with therapeutic work this early and this close in time to this event and this trauma, that they will be able to move forward knowing that this has nothing to do with them. This is their mother. But it's not them. It's not because of them. And also that there was nothing they could do. And that it's not their fault. And I hope that them being in therapy that early will help them process through that. Instead of waiting years and years and years and years and years to start to unearth it. So, I'm glad to hear it. It goes on to say what CR wants the court to know. And I'm glad the kids have had the ability to send letters to the court. And yes, that is the type of thing they can work on with their therapist to submit to the court. And I'm glad that they did. And I hope that that gives them a little bit of closure, knowing that they were able to share with the court their thoughts about their dad. So I'm going to try to read what CR wants the court to know and take a deep breath. CR wants to look, one of my hardest days at work, there were many very hard days at the DA's office. One of my hardest days was trying to read a victim impact statement. And I say trying because I sobbed through the whole thing. And the court was just looking at me. And I'm just like, I have kids. But it was, Emily, you're going to make it worse, probably. But we're already here. We're already here. The train has left the station. We're here. But it was a first person. It was written in the first person because the mother had wanted to read it herself. And then when we were in court, she was like, I can't read this. Can you read this for me? And I'm like, this is my job. I've got you. But also written in the first person about what happened after her son was attacked, who survived, not unaltered, severely injured, but survived the attempted murder, and wrote it in the first person. And I'm not going to detail it much more, but wrote it in the first person from the moment she got the call all the way through the hospital journey, including the life flight, the car ride, and in first person all the way through. And so at that point, Travis was probably 1.5, maybe, as I am sitting there reading this experience of her. And this happened right after her son's high school graduation, and talking about how she saw, this was a terrible idea, but either way, how she saw the life that she had seen for her child shift in a moment. But when they're 18, you think it's going to shift in a different way. And in a second, everything changed. And it was a beautifully and powerfully written impact statement. But it was so powerfully written that I was in it. Like reading it in the first person, in it. Absolutely in it. And it was one of the hardest things. And we did that. We're doing this. Deep breaths. Deep breaths. Deep breaths. Because all the feels are appropriate. It's horrible. And this is the cost. CR wants the court to know that my dad was a good person and very thoughtful and kind and helped whoever needed it. And goes on to say, quote, I'm afraid if she gets out, she will come after me and my brothers, my whole family. I think she would come take us and not do good things to us, like hurt us. I miss my dad. But I do not miss how my life used to be. I don't miss Kouri. I will tell you that. Wow. Well, the oldest of the Richins boys refers to Kouri repeatedly as she and then as Kouri. First of all, good for CR and CR's therapist for being able to distance Kouri to Kouri. This is the 13-year-old, now 13-year-old. To be able to distance Kouri to Kouri. But also, chat, just keep in mind, and in case you're in a place where tapping into rage is easier than tapping into the pits of sorrow in this, it's okay to just tap into that one. Just remember that Kouri's lawyers have to share these memos with her. Just keep that in mind. So Kouri will know. And yes, for those of you just coming in, the kids, as they are working on these statements, can work on these together with their therapists. And can be supported in sharing what they need to share and what they need to say. Emily Aarons asked if she was their biological mom. She is. She's their, well, yes. She birthed them. She has lost her parental rights at this point. And they have distanced themselves. But it is something saying from the children, I do not miss how my life used to be. And I don't miss Kouri. Kouri losing her parental rights also means that they do not have to have contact with her, which might be the most healing for them. A few of you asked if this will be read in court tomorrow. No, the sentencing memo doesn't need to be. The state can highlight it when they make arguments, but the entirety of the statements from the children will be submitted to the court. Those will be under seal. Okay. But the court will have the full statements. Julie Grass said this is hard for not name calling. Let's shift the name calling into support for the kids. This is incredibly powerful. It is a really hard thing for anyone at 9 years old, at 13 years old, at 30 years old, at 50, to put to words the pain that's been caused to them. And I think that's heartening to see. And I hope it helps heal them. AR, they say, this is one of the other children. AR was 3 weeks shy of his 8th birthday when his mother murdered his father. The defendant made AR her alibi, thereby condemning her child to be a material witness. Oh. If called to testify at trial. Oh. Emily, do you still stand by your position to not pre-read things and to read them with the law nerds? Yes. But also, if called to testify at trial, AR would have recalled being put to bed early on March 3rd, 2022 without bathing, which was unusual for the boys. Yes, because, well, after raising 2 boys, you need the water to try to calm them down before bed. Every night. Just all the time. Into the bath, into the shower, to transition to bed. Agreed. The television was playing loudly inside his parents' bedroom, and when AR tried to enter, he found he was locked out. Oh God, it gets worse. AR used a broom to try to dislodge a key from above the door frame, intending to unlock the door and enter the bedroom. AR accidentally hit the wall with the broom, making a noise that attracted his mother's attention. She yelled at AR to go away. She later entered his room and asked him what he needed. AR pretended to be asleep because he was angry with her. Later during the night, his younger brother, WR, woke and tried to enter his parents' bedroom to sleep with them, as was his habit. WR also found himself locked out and slept in AR's bed instead. AR would have testified at trial that the defendant did not sleep in his room with him the night she murdered his father. Oh. Oh. So the interviews with the children indicate that Kouri stayed locked in the bedroom to make sure that Eric was good and dead then, which is exactly what Bloodworth said in his closing argument, which has more weight than it did. Holy shit. I'm going to read that paragraph again because that's new information. If called to testify at trial, this is the middle child who was almost 8 when the murder happened. If called to testify at trial, AR would have recalled being put to bed early on March 3rd, 2022. This would be coming from forensic interviews with the kids. Without bathing, which was unusual for the boys. The television was playing loudly inside his parents' bedroom, and when AR tried to enter, he found he was locked out. AR used a broom to try to dislodge a key from above the door frame, intending to unlock the door and enter the bedroom. AR accidentally hit the wall with the broom, making a noise that attracted his mother's attention. She yelled at AR to go away. She later entered his room and asked him what he needed. AR pretended to be asleep because he was angry with her. Later during the night, his younger brother, WR, woke up and tried to enter his parents' bedroom to sleep with them, as was his habit. This is the youngest. WR also found himself locked out and slept in AR's bed instead. AR would have testified at trial that the defendant did not sleep in his room with him the night that she murdered his father. And then they have Exhibit B and B transcript, which means they probably included the video of the child's interview for the court. So the court, I imagine Exhibit B is the interview with AR, and then B-T would be the transcript of that interview. So now a lot of you have a question. Why didn't this come in at trial? If I were Bloodworth, and I'm not that smart, but if I were Bloodworth, looking at this case, I think I would do everything in my power to not call any of these children to testify. If there is any way you get to a guilty verdict without these kids sitting in a courtroom across from their mother to testify, you do it. If Kouri had testified, though, this would likely have come in at rebuttal. This is a really, really hard prosecutorial decision to make, because the prosecutor side is like, she's been lying from the beginning and used her kids as a shield, as an alibi from the jump. And then the human side goes, these children have been through enough. Making them testify in this trial is going to make it worse. And if we can avoid it, we avoid it at all cost. But also, the defense knew all of this when having those conversations. This is wild. Absolutely wild. That the kids were awake and tried to get into their parents' room, and it was locked. And Kouri was locked in the room with Eric, waiting. It's evil. It's evil behavior, and it's absolutely diabolical. Well, there's your LWAP. Holy shit. Holy shit. But providing the video and the transcript to the court means that the judge will see that interview before sentencing. Sorry, chat, we can't unwind the prosecution's intent not to seek the DP. Can't be unwound. All right, let's keep going. Oh my God. Look, when we look at the cases that we have covered, you can see the way different prosecutors proceed with their case. And with all of this, I have just so much respect for looking at your case and knowing that you can get there without calling the children. This is excellent testimony for the case. This is incredible testimony. This is convict in 15 seconds testimony. This is incredible testimony for this case. And choosing to protect the kids and not use it and rely on the intelligence of the jury and the strength of other evidence, I agree, is the right call. It is not a call everyone would make. And that deserves, A, to be called out, and B, I just want to highlight the balance that takes of, this is was it the judge who called it a high stakes game of poker? This is a high stakes decision, because if you don't use this and the jury acquits, or you don't use this and the jury hangs, then what? This takes a seasoned, smart, and unflappable prosecutor to make that decision, to trust in your jury and to trust in your evidence. Emily, you're stalling. There's more. But also, I highlight when prosecutors do stuff that's shit. It's only fair to highlight when prosecutors do stuff that's great. Continuing on. This was the right call, but it takes some confidence. AR wants the court to know that, quote, my dad can't be my coach anymore. Oh, we're doing such a good job, Emily. And can't be at any of my games. There are more words. There are more words that are happening. He won't be at my birthdays. All of the words. He can't teach me how to drive. He won't be at my graduation. He can't take me camping or fishing. It continues saying, quote, I don't want the defendant out of jail because I will not feel safe if she is out. With her in jail, I will be able to continue to feel safe and to live a happy and successful life without fear of her hurting me or anyone I love. They're afraid of her. Well, I guess we maybe know why the defense hasn't filed a sentencing memo. How do you respond to this? How do you respond to this? I don't think a sentencing memo has ever made me cry. If I'm wrong, fact check me and let me know. I don't think sentencing, yes. Sentencing memo, no. I don't think a sentencing memo has ever made me cry. Oh, ever. But the fear is just, it's real. It goes on to talk about the youngest. God, I don't know how I'm going to sit through the defense's argument at sentencing tomorrow, Because when they start to argue that she was like a loving mom and stuff, I'm going to lose my fucking mind. I'm going to lose my mind. I'm going to lose my mind. Because what do you mean? WR was still in preschool when his mother murdered his father. He has now had to live half his life without his father and 3 years without his mother. His memories of both are limited. He remembers being scared the night of his father's murder and wetting his pants while held in one bedroom before his Aunt Katie arrived. WR wants the court to know that when someone talks about Kouri, it makes me feel hateful and ashamed. She took away my dad. And if she got out, I would be so scared. I'm worried that she would take me away. Once she is gone, I will feel happy and I will feel safer and relaxed and trust people more. How do you trust humans when the person who is supposed to protect you most wreaks this kind of devastation on your life and your family? How do you trust people? And I hope that the court can restore some of that trust by saying, you know what, we've heard you. We've heard you. And you're safe. If the defendant serves 25 years in prison, she could potentially be paroled at age 57. Her sons will be 36, 35, and 30, and will likely have their own families. The boys deserve finality and should not have to revisit their father's murder at future hearings. That is an excellent point. That is an excellent point, Mr. Bloodworth. That if she gets 25 to life, they will likely be contacted by prisons and parole for what they think. There will always be a ticking clock on what's going to happen next. There will always be a countdown to will she get out. And the only way to stop that clock and to stop that countdown from living inside them forever is for LWOP. That is the only thing that shuts that door. That is a really, really good point. Because as too many of you in this chat know, waiting to see if someone's going to get out, if someone's going to get paroled, it's constantly with you. It does not leave. It's a great point. The boys deserve finality and should not have to revisit their father's murder at future hearings or worry about the defendant's potential parole. Given the tremendous amount of trauma and upheaval that the defendant inflicted upon their children, this court should ensure that she does not harm their adulthood. Not only should the defendant serve her life in prison, but she should serve her boys' lives in prison. This is the best closure her children can hope for. Only this court can give it to them. Goes on to say that Katie and Clint are now raising 3 boys that require extraordinary love, support, and stability. It is best for the boys, and everyone is thriving. But Katie and Clint never planned for it. Katie never planned to administer an estate and trust or tackle vindictive litigation. Gene never planned to work the family ranch at his age without Eric. Katie and Amy both live with guilt for not doing more to protect their brother from his wife. The aggravated murder's impact extends beyond the Richins family. Josh Grossman bears the weight of knowing that he contributed to the defendant's motivation to murder Eric. It has gutted him. God, you could see it when he testified. You could see it when he testified. It's really the only word that explains the devastation to Grossman as well. Chelsea Barney bears similar weight, knowing that the defendant murdered Eric in some measure to salvage Miss Barney's life savings. It haunts Carmen Lauber that she unknowingly provided the defendant with the fatal drugs. Cody Wright and Josh Kays question whether they could have done more to save their friend. Next heading. This has been a wild sentencing memorandum. There is so much new information in here. Wow. I have fuzz. I have tears. I have all the things. Okay. Law nerds, let's keep reading. We need more water. The defendant's character is irredeemable. The defendant is transparent. Evidence of her character is well known from all stages of this proceeding and include her prioritizing a facade of success over everything. Chat, I know you want a name call. I feel like you are going to get the velvet name calling of Bloodworth. She's transparent. I'm waiting for him to call her basic in here somewhere. She's not a good writer. Don't look. It's not even name calling, it's observations, but Bloodworth's got you covered. Bloodworth's got you covered. I wonder if we're going to get more jail calls. Oh, wait. Law nerds, take a breath. I feel like there is a potential that we get more information from jail calls. I feel that there's potential. Ooh, okay, let's keep reading. Maybe we might get there. Let's keep reading. Okay, into the defendant. Shift back out of the devastating sorrow, shifting into she's not even a good writer of it all. The defendant is transparent. Evidence of her character is known from all stages of this proceeding, to include her prioritizing a facade of success over everything, her fraudulent borrowing, her stealing her best friend's life savings, her persistence in murdering Eric after failing on Valentine's Day, her self-publishing a children's book for money and attention, and the aim of her walk the dog letter, among a slew of other examples. The defendant cannot check her ambition. I got another word for it too. Her sense of entitlement. When confronted, she lies. When she feels aggrieved, she attacks. And she certainly feels aggrieved. She always has. Damn. Bloodworth has her number. Bloodworth has had her number, but Bloodworth also gets to listen to her jail calls. Bloodworth has her number for sure. In the immediate aftermath of the guilty verdict. Wait, there's more. Oh, there's texts. In the immediate aftermath of the guilty verdict, the defendant blamed a corrupt prosecution, a corrupt judge, and unfair Summit County jurors. Girl! First of all, there are tears on my glasses. Girl! Look, my eyes are so puffy. Oh my God. I'm a mess. How dare you? How dare you? How dare you? Can you imagine Miss Ma'am calling Judge A, good Lord, calling Judge M corrupt is wild work. Holy shit. It's full Sarah Boone burn book. You're right, chat. So fucking wild. See the state's Exhibit C. Oh, I really hope it's attached. 6 weeks following the guilty verdict, the defendant text messaged an admirer. Okay, we're going to read this, but the chat has made a motion for code red. And I think between the corrupt judge, this was a fucking restrained prosecution, if anything. Corrupt judge, corrupt prosecution, and an admirer putting money on her books. She got sure a pen pal. Are they going to call into sentencing too? Chat has made a motion for code red. Chat, your motion is granted because the fuck are we doing? So, motion granted for code red because what the fuck are we doing? I'm between fuckery and audacity. We're just going to red. Chat asked for red. Motion granted, chat. Motion granted. Motion granted. Let me find our code red bumper. Okay, chat, here's the thing. Code red is flashy. If you are new, code red is flashy. The flashing ends when the music ends. So if you are flash sensitive, now is your warning. Because we are going to code red, motion granted. In 3, 2, 1. Okay, my lights didn't want to comply. My lights didn't want to comply with code red, but they were just slow. We'll get there eventually. They were just slow. Full fucking code red. Are you kidding me? Hold. My son is texting me. Hold on. The kiddo has texted. Okay. I'm trying to breathe. The defendant text messaged an admirer. Quote, I will, all caps. Because, right, no mods. Our mods are the best. I will expose this county that paid like $2 million for her to have a fleet of defense attorneys. I will expose this county, the prosecution, the judge, the Richins, the investigation, all of it. Oh, it is full burn book style. Girl, this investigation looked every which way but at you to begin with. Ma'am, you're going to have a lot of time on your hands. I'm going to need you to go ahead and look at the Sandra Birchmore case. You're going to have some time on your hands. You had an LSAT book. You're interested in what corruption looks like. I'm going to need you to look on the other side of the country. I don't need you to... Ma'am, this ain't it, girl. Take a minute to go watch the Afro Man case. You want to look for something because right now you're looking for tits on an ant because this ain't it. This homicide team came in and went, could it be an overdose? Could it be a heart attack? Could it be an aneurysm? Could it be a stroke? Every which way. And apparently we still haven't found Bryce's pants. They weren't looking at her first. They were looking at her last. But she's going to expose all of it. So they can lock me away for now. That's fine. It's going to come back on them. It will come to an end. Well, not the way you think. Not this year or next, but I'm not going away. I won't be silent. There's a apostrophe in that, but whatever. I am going to expose them all for what they have done to me. Exposed, right? I'm going to expose them all for what they have done to me, my kids, my family. This injustice, they picked the wrong one. Oh, girl, you're not that tough. They think sentencing is quote unquote the end, quote unquote closure. It's just the beginning. They haven't seen anything yet. Winky emoji. Right. So the kid's statements, she's just not even going to care. It's not even going to matter to her that she is not mom. She is she, or she is Kouri. At some point, she'll be that woman. Okay. They haven't seen anything yet. I mean, at least she capitalized most of the letters. So there's that. The prosecution goes on to say, most telling of her character, the defendant attacked Eric. Within hours of her arrest, she, for the first time, blamed Eric for his own death. And that's Exhibit E and E transcript. From jail, the defendant and her family engaged in an open, quote unquote, open season on, wait, what? I have to read this again because I buffered. From jail, the defendant and her family engaged in, quote unquote, open season on Eric the Dead. That must be what they referred to him as between them, and that's why it's in quotes. Releasing what they believed would be damaging information about Eric to the media. Oh, we talked about this. There was an article, was it Page 6? No, Daily Mail? I think it was Daily Mail. We went over this. We went over this when we were talking about, sorry, we needed more lippy for this. I've cried. I've yelled. We've gone code red. I needed more lippy. I think it was Daily Mail when we were talking about the motions in limine where they were just throwing Eric under the bus. It was, I think, Kouri's mom mostly talking to the Daily Mail. State's memorandum opposing motion to suppress letter. During trial, the defendant falsely accused Eric of having an affair with a coworker and a homosexual affair with one of his best friends. The Richins children are familiar with the inescapable media coverage of this case, right? Because they go to school. And one of them is 14, which means they go to junior high. And junior high is not school. Junior high, no matter how much our lovely junior high school educators do their best, junior high is a fucking thunderdome of hormones and nastiness. It's junior high. Many of the defendant's attacks against the Richins family preeminate the record, right? Because she started that lawsuit. Oh, we got to the throat punch. Look at this. Look at this. Look at this. For example, why did throat punch become one of my favorite words in this case? For example, she throat punched Amy Richins 2 days after murdering Eric when Amy informed her of the Eric Richins Living Trust. Yeah. Super normal reaction to attack your sister-in-law. I am being sarcastic and facetious. She throat punched her sister-in-law. Eric created the trust to protect Kouri and their children. 4 days later, she hired counsel to breach the trust. She told Jean Richins that Eric died of the same lung mold that killed Jean's wife. Cruel. Period. Again, I think that's observational, not name calling. In the walk the dog letter, the defendant instructed her mother to release photographs of Katie's young children to the media and wrote, quote, "Bring me home and then we'll get those damn bitches." For those of you that do not remember that part of the walk the dog letter, I covered it a couple times. A lot of it was redacted at trial because, again, more prejudicial than probative. More fuck you than did you fucking do it? Damn. When confronted with the letter, the defendant insisted in the face of all reason that it was part of a freaking book. Emily, where does that quote come from? Kouri's jail calls, because they've been in other motions. To her brother. It's a freaking book. It's a novel. You guys, it's the most noveliest novel to ever novel. It is a
thorough and world-renowned and famous and most literary novel to ever novel. It is like 67 pages long. 67. And it is the best to ever do it in the game. Super detailed novel. It's a freaking book. I'm a writer. What? Can't hate the game.
Ugh. It's a freaking book. Other of the defendant's attacks against the Richins family, and y'all, I don't remember if she said it was 67 pages or 68 pages. It was in there, so we're defaulting to 6-7. We were just talking about junior high. It's the only proper thing to do, but it's in that realm. Other of the defendant's attacks against the Richins family are new to the record. Oh no, there's more? Bloodworth was like, get out. Bring the kettle. I have tea. The kettle's been brought. I didn't know I needed to put water in the kettle for today's episode. I didn't know that this sentencing memo was going to have a roller coaster of new information, emotions, and statements from the kids. Oh, boy. Other of the defendant's attacks against the Richins family are new to the record. Mention it all, Bloodworth. Mention it all. Just mention it all. Wait, where is it?
Mention it all. Mention it all.
Mention it all. Mention it all. For example, when the estate's investigator, which would be Mr. Gabler, I would imagine, when the estate's investigator found bank statements with Kouri Richins Realty's account header and C&E's account details, the defendant accused Katie and hired counsel to advocate for the criminal prosecution of Katie. While detained pretrial, she caused her family members to pursue federal firearms charges against Jean for removing Eric's firearms from the Willow Court home for safekeeping. That's what she was trying to do? Of course, Eric Richins' family wanted to remove weapons from the home before Kouri was removed from the home. Kouri was at the home for a year after Eric died, and Eric's family was like, she did that. Of course you don't want her to have guns at the home. Tried to get them to bring federal firearms charges against her father-in-law, former, for moving the guns to a different house. Filed false reports with DCFS against Katie and and reported Amy Richins to the police for marijuana possession. The fucking hypocrisy. The fucking, you're calling from jail to yell about someone else's weed gummies? Really, Miss 420? Seriously? She was like, fine, if nobody will get these bitches, I'll do it myself. I'll get these bitches my damn self. Oh my God. For those of you that are newer to the chat, Kouri Richins' birthday is in fact 420. I'm not joking. I had forgotten for a while that her birthday was 420. Her birthday's 420. You throat punch your sister-in-law and then you try to report her for having marijuana. For those of you that were asking for what snacks are appropriate for tomorrow, maybe it's gummies. Not for me. At this moment, I'm in Tennessee. However, if it's for you, go for it. All right. What else did she do? To this day, the defendant maintains insurance policies on the lives of her children. The Richins family will not be safe if the defendant is ever paroled. The defendant's attacks extend beyond the Richinses. While detained pretrial, the defendant caused her family members to file unfounded bar complaints against the Summit County Attorney and Chief Prosecutor and post a gay dating profile of the lead detective online. That is some stupid shit. What are you doing? Kouri, what are you doing? Also, bar complaints against Bloodworth? Florals for spring? Riveting. What are we doing? What are we doing, Kouri? Somebody's taking the lead detective's photo and creating dating profiles online. And then probably going around saying, oh my God, did you see this? Ma'am, if you have the chisme from in custody that is about things happening on the outside, it's because you're creating it. Oh my God. That's wild. That's wild. Also, stop being so obsessed with people's sexuality. Damn. The defendant also made an unfounded criminal complaint to the FBI about Eric Richins' business partner.
The FBI!
Miss Ma'am, transparent really was the best read at the beginning of this.
The FBI!
The defendant's character is evident despite her well-crafted facade. I mean, it's not that well-crafted, let's be honest. Eric surviving Valentine's Day, 3 years of pretrial detention, and a resounding guilty verdict has only amplified the worst of her character. It did not remedy it. She has expressed no remorse and has indeed publicized the opposite. Calling the judge corrupt is a real bold choice. A real fucking bold choice. You think people aren't listening to your jail calls? I mean, they're probably fucking sick of hearing it at this point. But this is why they have to listen to the jail calls. Every single case. We have jail calls between conviction and sentencing. Not everyone, most. Where the defendant is saying some stupid shit that's going to come up in sentencing to show that they are indeed not remorseful. The irrational nature and circumstances of the aggravated murder its irreparable impact on the Richins family and others, and the defendant's irredeemable character prove overpowering aggravation. It's literally OP. We have gone from OPP to OP. It's overpowered, completely OP. Any mitigation the defendant presents will only be more facade. It is all she has. The read. It's just all fake. It's all toothpicks and spackle. Oh boy. Well, I don't know if I even expect the defense to respond after this. Like, what the fuck do you say? Your Honor, they're bullying me. Hold on, I'm gonna see if anything has gotten filed before as we continue to do this, because it takes the docket a minute to populate. And it takes me a minute to do a freaking CAPTCHA. Good Lord. And then we'll I'm just curious to see. Again, if the defense files anything today, I will let you know in the Lawnerd app. If they respond to this, I don't know what the response will be. But if there is one, I'll keep you posted. But how do you respond to this? Your Honor, the prosecutor's mean. Woo! The read on that. The prosecution goes on to say, but even if credited, like even if the court is like, okay, this is a mitigating factor, but even if credited, it cannot outweigh the aggravation. Accordingly, the defendant has earned the maximum punishment short of death, and the public safety requires her permanent incapacitation. Yeah, incapacitation by incarceration. Fair. She is well established that rehabilitation is beneath her. LWOP, combined with the intense publicity cultivated by the defendant and her counsel, will also deter would-be prisoners from coldly murdering their spouse and their child's parent. There's the deterrent effect. The court should sentence consecutively on counts 2 through 5. The gravity of the attempted murder is that the defendant learned from her mistakes. She learned to obtain, quote unquote, something stronger and to administer it in a way that prevented Eric from realizing the poison's effects until it was too late. And in my conversation with Todd Gabler, he talked about that. If you put it in a shot, it's too late. It's in. And when we were having that conversation, the shot first and then the Moscow Mule to follow it might account for why there was some in the blood and some in the stomach, because there were two points in time where that was administered orally. It goes on to say that the gravity and circumstances of the frauds and forgery punch above the charge's weight because they encompass the defendant's motive for murdering Eric and the pecuniary gain aggravator. The defendant's character, as discussed in section IC supra, is irredeemable. Accordingly, the defendant earned distinct punishment for counts 2 through 5, and the court should sentence them consecutively to any other sentence, one after the other after the other. The court should enter a continuous protective order in favor of Eric Richins' family members. I like this. I like it. The defendant was convicted of domestic violence, aggravated murder, and attempted aggravated murder. Utah's criminal protective order statute provides that when a perpetrator is convicted of a domestic violence resulting in a sentence of imprisonment that is to be served after conviction, the court shall issue a continuous protective order at the time of sentencing, limiting the contact between the perpetrator and the victim unless, 1, the court determines by clear and convincing evidence that the victim does not have any reasonable fear of future harm or abuse. The protection may include any order, quote, the court considers necessary to fully protect the victim and family members and members of the victim's family. And then it cites the Utah Code. Here, Eric Richins is the only quote unquote victim under Utah's victim crime statute. Paradoxically, Eric Richins' family members, including his children, are not quote unquote victims. It is evident that Eric Richins does not have a reasonable fear from future harm or abuse because which is the criminal protective orders statute threshold inquiry. Thus, the criminal protective order statute yields the absurd result that family members of a domestic violence murder victim are left unprotected when family members of all other domestic violence crimes can be protected. It's a good argument. Bloodworth is making sure to kind of close the legal loophole or question that if there was just an attempted murder and the victim was alive, then there could be a protective order for the victim and the victim's family. But if the victim is deceased, then you can't have a protective order on the victim and the family. So why shouldn't you be able to just have one on the family? And so kind of closing that loophole on the result and asking the court to close that loophole that the law clearly doesn't intend that decedents' families aren't protected if it's reasonable under the, if it's reasonable by the, if the court finds that it's reasonable. They go on to say that this is where the absurdity doctrine comes into play. He's not making that one up, you guys. That there are circumstances in the law where the legislature is trying to protect a certain circumstance, but without adding a few words or without carving out an example, you can have this mixed result that if the victim's alive, it's result A, but if the victim's dead, it's result B, but result B doesn't make any sense. And so absurdity is not a takesy v. backsy, or as we determined last week, pretty v. please. The lexicon of our case law is growing, but meaning that you can't intend to have these separate results. Bloodworth says this is where the absurdity doctrine comes into play. Courts will apply the absurdity doctrine when the operation of the plain language is so overwhelmingly absurd that there's no rational legislature that could have intended the statute to operate in such a manner. This standard is satisfied only if the legislator could not reasonably have intended the result. The legislature was not thinking about murder cases, it seems, when they wrote this, which understandable, but also not the result necessarily intended. Bloodworth goes on to say that this standard is satisfied here. Clearly, the legislature, easy for you to say, Emily, clearly the legislature, blah, 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 blah. Apparently that's just how we're saying that today. Could not have reasonably intended to exempt the family members of domestic violence murder victims from protection. Well, now that it's been brought to their attention, they can also change it. The defendant's conduct and the victim impact statements firmly establish that it is necessary for the court to protect CR, AR, and WR from their mother, as well as Eric's father and his sisters and their families. Anyone can appreciate the family's fear resulting from the defendant maintaining insurance on the boys' lives. Well, and her statement that this shit ain't over yet, and get me out of here and we'll get those bitches. Yeah, for sure. In other jurisdictions, the definition of victim when it comes to murder victims is extended to include family. So it really just depends how jurisdictions navigate their definition of whom is counted under these statutes as a victim. And when surviving family members are not included in those statutes, then you end up with this result that I don't think is what the legislative intent was. They go on to say that the court should order the defendant to pay restitution. Utah's Crime Victim Restitution Act requires district courts to determine restitution for any pecuniary damages approximately caused by the defendant's criminal conduct. Insurance companies are quote-unquote victims under the statutory definition. Additionally, the defendant is a quote-unquote killer within the meaning of Utah's so-called Slayer statute, which provides that, quote, a wrongful acquisition of property or interest by one who kills another shall be treated in accordance with the principle that a killer cannot profit from the killer's wrong. We have covered Utah's Slayer statute a little bit in conversation about the civil cases that are still pending here, because it was brought up early on in these civil cases. I think Kouri has to the end of the month to find new lawyers on that. We'll see. The defendant received over $1 million from Auto Owners Insurance Company, over $352,000 from True Stage Insurance Company as the beneficiary of insurance on Eric's life. The insurance companies paid out as a result of the defendant committing aggravated murder as convicted in count 1. Moreover, True Stage paid out because the defendant committed insurance fraud and forgery as charged in counts 3 and 4. Accordingly, the court should order the defendant to pay restitution to the insurance companies in the amounts listed. I'm not reading them again. The court should order the defendant to pay recoupment to Summit County. After Ray, Quinney, and Nebeker abruptly withdrew from this case in May 2024, the court declined to require the defendant to complete an affidavit of indigency, citing Fifth Amendment concerns. Oh, I guess that's fair. Because for the defendant to complete an affidavit, the defendant would have to swear under penalty of perjury what assets the defendant had or had access to. And there are fraud counts in this case. So having the defendant disclose or discuss their financial situation may in fact be a problem. It's crazy to me that Kouri's out here calling Judge M corrupt, because the word that comes to mind in some of these things is that Judge M is cautious. Judge M is mindful and cautious. The court found that the defendant was indigent on the sole basis of former counsel's representation that, quote, the defendant does not have access to financial resources sufficient to retain private counsel, emphasis added. Summit County thus became statutorily obligated to provide defense services to the defendant. The cost of those services will exceed $1.3 million. So that did not encompass the amount of prosecution. That was the amount of defense. Okay, that makes sense. Can you not charge the cost of, not every jurisdiction you can charge the defendant the cost of prosecution. So you might not be able to in Utah. It goes on to say the court learns that an individual provided with an indigent defense services, if the court learns that an individual provided with those services is in fact not indigent, the court shall order the individual to pay the defense system the cost of the services. The defendant continues to litigate claims to Eric Richins' premarital home and a share of the trust res, which is the stuff, the monetary value of the stuff in the trust. To the extent any of those assets or other assets are adjudicated to the defendant's property, the court must order the over $1.3 million of those assets paid to Summit County as recoupment for the defense services. If she wins on any of those civil cases, which she may not, but if she wins on the civil cases, it should pay back the system to pay for her lawyers. That makes sense. Additionally, the court may order a defendant to pay costs for expenses incurred by a political subdivision of the state for attorney's fees of counsel assigned to represent the defendant. To the extent the defendant or her representatives or assignees receive any money that is not subject to the Profit from Notorious Criminal Activity Act. So in addition to the Slayer statute, unless the Slayer statute is the nickname for the Profit from Notorious Criminal Activity Act, the court should order the $1.3 million paid back to Summit County as recoupment for her defense attorneys. So that is the cost, not of prosecution, but the cost of her defense. Conclusion. The court should sentence the defendant to life without parole. Among the state's other sentencing requests, this sentence is appropriate considering the crimes that she committed, their impact on her children and Eric Richins' family members, and her irredeemable character. This sentence serves the interests of society, which underlie the criminal justice system. Most importantly, no other sentence can provide the children, CR, AR, and WR, the comfort and protection that they need and deserve. Holy shit, that's a sentencing memo. And there it is. That is wild. Wow. The attachments to the sentencing memo are sealed. The pre-sentencing report is sealed or are protected. The sentencing hearing is set for tomorrow. There will be subsequent hearings. Let's summarize and talk about this real quick. There will be subsequent hearings to sentencing for Kouri Richins because she still has the financial crimes case. Remember, her defense attorney said that they would, and reluctantly so, that they would take on standing in essentially as her attorneys on the financial crimes case, but they did not agree to be appointed on that case. So she will need new appointed criminal defense attorneys for the financial case that's following this. And that financial case is just trailing behind this one until this is done. Once this case is done and sentenced, they might find a way to resolve it. I imagine they are going to want restitution ordered to Barney for the loss of life savings and to others. But if she gets sentenced to LWOP, I imagine they will be able to resolve that other case, because what would be the point of the money and resources spent prosecuting it? We would all be happy to see another trial. Summit County, on the other hand, might be like, we have spent enough money and time and energy on Kouri. Would we all love another trial with Bloodworth and Judge M? Yep. Sure would. Summit County's probably like, and we're done. But we're going to keep an eye on the financial crimes case that's trailing this one, because there is another date set for a status hearing in June. So she's going to need new lawyers. She already needs new lawyers in all the civil cases. She's going to need new lawyers on that criminal case. The sentencing tomorrow, the judge has set aside the entire day. We will be streaming it live. Bring your Kleenex. As I said at the top of the show, and I'm going to remind you again, we will let you know in the Lawnerd app when the impact statements are being read, when the impact statements are done, when the defense is presenting their side and any witnesses and mitigation, when the attorneys are arguing. We're going to give you a lot of notifications tomorrow. When the attorneys are arguing their side of the case, and when the judge goes to pronounce sentencing. Will that go over lunch? Will that not go over lunch? I do not know. I plan on being with y'all all day tomorrow. That's the goal. So I think we will be here all day for sentencing. What time does that start? We will be starting at 10:45 Eastern. Not Eastern. Incorrect. Where's Emily? She's really, really late this time. No, your girl runs late, not that late most of the time. 10:45 Central. Sentencing is supposed to start at 9:30 Mountain. We're going to give it just a little bit of zoom room tomorrow, but not much, because I don't want to miss doing that with y'all. And if that means we've got some breaks, then we've got some breaks and we'll figure it out. So tomorrow is going to be an emotional day. I did not expect sentencing memo to be an emotional day, because yikes, I was not prepared. I was not prepared. We're going to summarize it because, oh boy, we're going to summarize it. So tomorrow, 10:45 Central. So about a half an hour before we normally go live, to be for real. Not too soon before we normally go live, very close to our normal live time. And then we're going to watch the sentencing together. I'm going to bring Kleenex. It is going to be emotional. It is going to be an emotional sentencing. What we have learned from this memo is there is still more that we don't know. There was a lot of new information in this memo. New information that Kouri, after the verdict, is like promising her revenge. It's wild. This, and I can't wait till one day we get to see the attachments on this. But look at this. 6 weeks following the guilty verdict, Kouri messaged an admirer. And yes, they can message. They have prison devices. I will expose this county, the prosecution, the judge, the Richins, the investigation, all of it, so they can lock me away for now. That's fine. It's going to come back on them. She's like, you know, a curse on your cow is where we're at. It will come to an end. Not this year or next, but I'm not going away. I won't be silent. I am going to expose them all for what they have done to me. My kids, my family, this injustice. They picked the wrong one. They think sentencing is, quote, the end, quote, closure. It's just the beginning. They haven't seen anything yet. Oh, girl. Okay. Sure. So if I'm the judge and I'm looking at what the balance is of, is there remorse here and is a protective order needed? I'm going with yes, a protective order is needed, and no, there's no remorse here. Just, I'll get you. And then when you add that to what we learned for the first time in this sentencing memorandum, we saw brief statements shared from what the children have written to the court, saying that they are afraid if Kouri is released, referring to Kouri as she and as Kouri, and talking about the fact that their life before their father was killed was not great. We also saw for the first time detailing of what the middle child, who was asleep downstairs, would have testified to. And that new information is that Kouri did not go and fall asleep in her child's bedroom. That when the middle child and the youngest child tried to go into their parents' bedroom that night, they found the bedroom door locked. And the middle child tried to get the key off the top of the door frame with a broom that banged against the wall. And then Kouri yelled at them to get back to bed, then did go into the room to check if they were asleep. And the child pretended to be asleep because they were mad at Kouri. Her entire statement was, I went into my kid's room and fell asleep. I got up at 3 a.m. I went into the bedroom. I got into bed. It felt weird. Eric felt too heavy, on and on. And what we learn here is that Kouri was in the bedroom, locked in the bedroom with Eric, which gives new emphasis to Bloodworth's closing argument when he said she didn't just want Eric dead, she wanted him good and dead. Because based on this, it sure seems like she waited in the bedroom from after she made those drinks till just around 3 a.m. to call law enforcement to ensure that this time he was going to be dead. Not in the child's room, but that she also made her children witnesses. She talked about the children trying to come into the room on the 911 call. At that time, I had thought it was related back to her calling 911 and being loud and trying to kind of work herself up into emotion. But I wonder if when she was talking about her kids trying to come into the room, she was actually referencing earlier in the evening. So there's a lot more to this case at sentencing than I expected. There is still more to come. And also, for all of the extensive amount of time that the defense banged on about Kouri's character being filleted in the media and people talking about this being a Moscow mule and there being too much information out in the media for her to get a fair trial, this never came out. Some of the things most damaging to Kouri were still to come. And they all knew it. We didn't. The jury pool didn't. Can you imagine? Leonard! Can you imagine the jurors hearing this for the first time after trial? The jurors are like, I mean, I knew I was right, but like, I know that I am right. Because when we talk about not all the information coming in at trial, they didn't know about the throat punch either. That's going to be a new reveal to the jury. But this is a lot of new information for the jury. And information that could have come up at trial. And I think it was the right call that it didn't. Though if Kouri had testified, it might have needed to. And now the judge is going to know it too. And the rest of us as well. I wonder if we will hear more from this tomorrow. The judge will have it. So people can submit statements to the court that the judge can have and read. The defense can do that. The prosecution can do that. So the court will have those statements, including, I imagine, the entirety of the children's statements. Tomorrow we will see impact statements. Those in Eric's family can all make their own impact statements. The purpose of an impact statement is to tell the court the impact this has had on you. Everyone treats those differently. And we have seen courts have varying levels of leniency with impact statements. We have seen family members be asked to leave court during impact statements when they have gotten too heated. We saw that in the Brooks case. We have seen courts just sit back and say, send it, like we saw in Kohberger, because the court's like, oh, you're ready to read the defendant up one side and down the other? I mean, it's the impact it's had on you. Go off, sister. Literal victim sister. So we have seen a varying level of tolerance for the courts. I would imagine that Judge M is not if you start hollering, name calling, he's going to let it slide kind of a judge. I don't get the sense that that's Judge M's vibe. I get the sense that Judge M is talk to me, tell me how this has impacted you. Do not just turn around and start cursing out the defendant. Though I also don't get the sense that that is helpful for the victim's family in this case either. So we will see. And we will see what boundaries the judge puts on that. I imagine the judge will remind everyone that if they are overly emotional, they can take themselves out of the court. So there is going to be emotion in tomorrow for sure. the judge has to balance that. And judges have different thresholds. I think we have seen a tremendous amount of patience from Judge M. I think that patience will also extend to the victim's family. I think we saw that in Judge M saying, no, we're not giving you any more time for sentencing. We're not delaying this. This is the day of sentencing. This is the day of sentencing. We're doing it now. And I have always said that when judges are particularly cautious during trial, it is one of those things we are not going to see circle back around on appeal, right? We are not going, I mean, they'll argue it, but we're not going to see appellate courts having massive issues with anything in this trial. There were some times I'm like, oh, Your Honor, now's the time to put your foot down. However, it protects the case on appeal. And I think the leeway and the patience that the court is extended is going to end tomorrow. And then the big question is Kouri going to have anything to say? She can choose to make a statement. She can choose not to make a statement. Are we going to get full Sarah Boone? Or are we going to get like Donna Adelson? I don't know. I don't know if Kouri's going to have anything to say. If Kouri has people coming in court talking for her and saying the things she wants them to say, I think my odds go down on whether she wants to say anything. Then again, Sarah Boone modified what she was going to say in court. And then what? A week later said, nah, fuck this, and sent the entire thing into the court. It was like, I held back. I regret it. Here you go. So I don't know. I'm going to put up a poll. Chat wants a poll, and then we're going to get to questions. Chat wants a poll on whether Kouri will have anything to say at sentencing. All right. And when I say, will Kouri have anything to say, this includes whether or not she will have the defense present a written statement on her behalf or whether she will talk. It's inclusive of both. All right. That yes, no poll for you in the chat. Let's get to some of your questions. I'm real curious to see what Kouri is going to do tomorrow. All right. Time for questions. Where did I put questions? Questions are down here. Let's go. I know it's a vibe. We have a whole new launch. We have a whole new vibe. Things have a new vibe. There's a new vibe. There's a new vibe. We've got our new vibe. We've got to. All right. First of all, let's put these lights back. Let's get out of our code red real quick because we need to get back to our normal stream. Though maybe the code red mitigates the crying face of today because Lord, today. All right. Let's take a look. Some of our Lawnards are sharing that they've already gotten their merch. TN Lawnard said, got my merch. I'm so excited. If some of you are saying, how in the world do some of the Lawnards have the merch? Exclusive access for the Lawnard Lounge. That is how. I'm so glad, TN Lawnard. Congratulations. I'm not sure which shirt I'll be wearing tomorrow. Maybe our tour shirt tomorrow. Maybe my comfort hoodie tomorrow. I might be in the hoodie tomorrow. I might be. So congratulations to everyone. Yay. Rhiannon said, my youngest is graduating this year. It's so hard. Nameless musician said, I'm 1,000% with you. Got a sprained ankle, a kiddo graduating on Saturday, laundry piling up, and another kiddo dealing with the Canva outage or the Canvas outage. I am so sorry. It's so much. May is spicy. May is just like this. Paula said it's nice having a stream on your birthday. I felt the same way. And that's why we had our members only that I was supposed to set an alarm for and then didn't. And Dr. B's like, what happened? I'm like, I started talking and then we were telling stories and then it got really late. And then it got really late. Sally says, I get that Canvas needed to take better protective measures, but how are they, the schools, not considered victims? I think that they would. I mean, they would be victims of the hack from, I mean, by proxy, I suppose. But I am curious if the schools are going to be suing Canvas for their losses dealing with this hack, given that Canvas knew about it more than a week before they told the schools. I wonder if that gap in time is going to be where the lawyers are like, no, this is not okay. David Reese says, my daughter's school uses Schoology and they were selling personal data to the students and parents. Oh, and then corrected, actually, it was Power School. That's awful. That's a lawsuit waiting to happen too. A big lawsuit waiting to happen. I love that you guys are loving the new emoji. Thank you. Cat Scratch said, my security clearance data. Oh, geez. That's awful. My security clearance data was leaked during that government breach years ago. I am like, oh shit, here we go again each time it happens. Yeah, it's quite a lot. It's quite a lot. Jan, I'm so sorry. Jan said, EDB, I am hoping this stream is a fun stream. I don't pre-read our documents, and I am sorry. I need to take my mind off the 5th year anniversary of my mom's passing today. Jan, I'm sorry for your loss. I fear that this stream probably pulled up a lot of grief for a lot of folks. New information, though there's a rage side that can easily be tapped into in this. There's a lot of grief in this as well. It's heartbreaking. It's heartbreaking stuff. It's heartbreaking stuff. And the levels of impact that were still unknown to us is wild. But I'm glad it was shared. I'm really glad that Bloodworth put all of that in the sentencing memo. I think we have a preview of what we're going to see tomorrow, and I imagine what we're going to see tomorrow is a lot. But also, so the defense just isn't going to file anything. Just not going to file anything then. So, maybe not. Bender is great. We talked about the cups not being a part of this launch. We also did buy the entire stock of these tumblers the last time we launched, and they took a little bit of time. So we chose not to do cups again just because of shipping this time. We also had some substantial inventory issues with those. So we will see. Ippy Fluffy in the chat said, can they file last minute? I mean, they can do whatever they want. So they can file it whenever they want to file it, but I'm keeping an eye on it. I'll update you in the app. I don't know how you respond to that. They might just do it in court. We will see. We will see how that goes. Serena said, I'm obsessed with the tour docket. Whoever had that idea, genius. It was very much something I wanted to bring to light. And then as a team, I was like, we need a tour shirt. And then as it started to coming to life, I'm like, oh no, we can call it the docket. That's really the title of the tour. And then we grew from there. And I'm like, and then we can make more. So it is my intention that our tour shirts, hold on, where is it? That our tour shirts, this one is our 2020 to 2026, because we have not done one yet, but that we get to add to our tour shirts as the years and the cases go. So there will be tour shirts. There will be tour shirts. So I was very excited. I'm like, and we can do more. And we can do more. Yay. Gossip, rumor, the gossips, the rumor. It's good to see you. So Bloodworth is not playing. Bloodworth. And here's the thing that's so crazy to me is that I would normally say at this point, the prosecutors put it all out on the table. Like I still don't think we're there yet, though. After we've seen all of this, I don't think we're there yet, though. So maybe more code fuckacity. the murdacity. Yeah, the fuckery was a lot. So, and Bell said the book on grief was ghostwritten. I know the industry, Kouri is not a skilled writer. Oh no, we learned that in trial. It actually came in trial that the grief book was ghostwritten. Because I don't think Kouri knows how to explain the emotions of it, because I don't think she had the emotions of it. I don't think Kouri had the emotions. I think her emotions were relief, and that's not really what you're going to put in a book about navigating grief with your children. So, unless you were talking about, I don't know, awful terminal illness, and then you were able to navigate all of the complex emotions in that, this is not that. For sure. Drake Duke said Emily should try to buy Spirit Airlines. No, CEG, the beginning of this where I was crying about the cost of shipping. No, I don't have the fortitude to try to navigate that. No, not at all. Not at all. But thank you. Aletha, I hope I got that right. Dason said, oh my God, I think she watched him die. Her son almost walked in on that. If anybody had any doubt. Yep. And then added, I'm gutted. It is devastating facts. I am appreciative that we have a heads up before tomorrow, because I'm glad we have a heads up before tomorrow. Stephen, this is a great point. Gardino, the Forever 411. Can Judge M give a scathing rebuke during sentencing for this case and not have it impact the fraud case if he's the presiding judge? It is a fantastic point, because he is the judge on the fraud case and the family law case. And I think no matter what Judge M does or says, him sentencing her in this case will be brought up in the other cases. I don't think it impacts it. Judges are able to see things separately, but I imagine it will be brought up. Yeah, I think so. Virginia, thank you for the 5 gifted membership. Let's see. Disney Babe 76 said, I'm an hour behind. Listening to the children's account of the night their dad died is awful. Yes, and has me completely in the feels. I just want to get all of the hugs. Yes, and just hugs to this whole family. But they have a family unit around them. They have support around them. There were notes in this from Bloodworth that the children are doing well. You saw that within what was written, that they have support, that they have family, and that they are doing well. And it's nice, because we often have so many questions about what happens next, to hear just a little bit of that. So I'm glad we saw it. David Reese said Power School settled for $127 million. That's wild. That's going on my list as I keep looking at this Canvas stuff, because what are you doing? What are you doing? Anthony, thank you. I will go look. I know some that are marching Crown this year. Also, to totally shift gears for a second to talk about band. It's not shifting gears entirely, but it is. But to talk about band. I have been seeing teasers for shows already starting, but also my son's DCI group has been posting countdowns every day. The countdown to spring camp is so hard because it's the countdown to Travis moving out. He's excited. His core is excited. They have some social media teasers going on with their show, but also the daily countdowns of this many more days till move-in. I'm just like, panic. So I am excited and looking forward to start seeing the teasers for the shows that the different cores are going to put on the field this year. But also, I am not ready. Anthony, that does not help. This does not help. Spring training starts in 10 days. This does not help. But also, yep. It's time. It's DCI season, everybody. It's time. So I am very excited for core, but the Cavaliers have been posting. Mib68 says, where are they posting? I'm following them on Instagram and haven't seen anything. They changed their profile picture on Instagram, and they posted a photo of the new profile picture on their Instagram stories. So they are very subtle. But again, I noticed that it was a posting of, let's see if they put it on their website. It was a posting of their new Instagram profile picture. Let's see if it is on their website. If not, I'll just pull it up on Instagram and see if I can share, because I have thoughts. My kiddo also has thoughts. So, I mean, I guess we have thoughts. Let's see. I'm just going to have to pull it up on Instagram. I'm trying not to make anything autoplay and be loud, but for those of you that do follow me on Instagram, you will see me sharing stuff about Cavaliers, DCI, and about other DCI groups. My son is a Cavalier, so I will always be posting about Cavaliers first. But I am a fan, first and foremost. I'm a fan of my kid, first and foremost. I'm not objective at all when it comes to it. I will tell you the other shows that I enjoy. But when it comes to my kiddo, he has better objectivity than I do. All right, here's the new Instagram handle. Look at this. Stay true, live long, never grow up. Stay true, live long, never grow up. 2 stars. That right there is, hold on, come back, Instagram. That right there is like a Peter Pan Lost Boys show. That's what that is. Look at that. That right there is a Peter Pan / Lost Boys show. Look at it. Look at the font and the 2 stars. It's going to be great. It's going to be great. I'm very excited. So I think that teaser is, well, I don't know if that's much. I think that's a spoiler. I don't know if that's a teaser. I think that's a spoiler. The Never Grow Up. And the reason I say Lost Boys, for those of you that are not familiar with Drum and Bugle Corps, the Cavaliers are the only all-male corps in DCI. And I can see them doing a Lost Boys show. I think that will be very cool. I am very excited. And then the barbed wire, it's just a vibe. It's a vibe. I'm excited. I am ready. They had a camera at the top of Lucas Oil. Look at this. This is on their Instagram as well. Of their field show. This is sped up, but it's just so freaking cool. I love it. Emily, you're kind of in the way. I know. I moved things around yesterday. I'm going to have to move them back. But that's their field show from the Bird's Eye View at Lucas Oil Stadium. That's their finals from last year. So we'll see. I'm very excited. I loved their show last year. I really enjoyed the music. I enjoyed the props. But I'm very excited to see what they do this year. So very, very excited. MB said, we don't have this in my country. Is this USA only? The corps perform in the USA, but there are many marchers that come to the States to perform in the summer. So there are international marchers, but they perform all across the US. It's an insane thing. It's amazing and it's insane. And they are all, I mean, the US is huge. They are all over the US performing in the summer. And they do have marchers that are international, which also has to be a total trip to be like, why is Texas so big? Like when you're traveling across Texas in a bus, like, why is it so, what is this? Like, imagine their tour had a marcher from the Netherlands. And then trying to explain Houston in July. And you're like, so this is a lot. This is a lot for sure. So I'm excited. I didn't know if there were any other. Let's see. My kiddo was in one of these photos. The Cavaliers won the backyard brawl. They raised more money than Phantom Regiment. Phantom Regiment, of course, from Rockford, Illinois. We'll be talking about Rockford, Illinois more soon because we will get back to the Tepe case in the weeks to come. Let's see. I think there was a photo of T in here somewhere. I just don't remember where it got posted from training camp in April. It was here somewhere. I'll find it. I'll find it and share it on Instagram again so you can all go drop some purple hearts and confuse the shit out of the Cavaliers social media team for a second year. I mean, they know now. Last summer, they were like, what's happening? And I was like, don't worry about it. That's my kiddo. But I will, let's see if I can find, I don't remember which one it was. I'll find it and share it. Emily, you're still looking through Instagram. It's time for tour. Look, man, it's exciting. It's exciting. It's a whole thing, and I love it. Broccoli and Lilacs, this is a great question. Has the judge pretty much decided on her sentence? It really, really depends on the judge. So most judges will have an idea of what their options are. Some judges will already have their sentencing memorandum written. We saw that with Judge A. Judge A had the sentencing memorandum written out for the 10-year sentence for Juliana. Some judges won't have it written out yet. Some judges will leave themselves options. But the judge knows that there are basically two options in this. And I'm sure the judge has already been thinking about it. It is a big decision to make. And the judge knows most of the facts here. So there are things that will come up at sentencing, but I think the judge will have an open mind, but an idea of what they are thinking, because it's not a decision you want to make in 3 minutes. It's a big decision. So I think that the judge will have an idea, but it goes judge by judge. So yeah, it really just depends. All right. What else? So, Julie B, this is a perfect distraction. Emily, some days it's not, some days it is. Yes, today is a perfect distraction. Today is a perfect distraction. Not to distract from the horrible mother that Kouri Richins was, have you looked into Alec Murdaugh case being overturned? Any updates on that? We talked about that last week. There are rumors, but the Supreme Court of South Carolina has not issued a ruling. They issue their rulings on Wednesdays. So there have been rumors and there have been discussions about whether or not the court is going to overturn the Justice Toll denial of the motion for new trial. So when the South Carolina Supreme Court rules, which if they drop that tomorrow while we're in sentencing, I'm going to have curse words for them. Curse words will be had. They drop their rulings on Wednesdays. Sweet and salty, I do not think DCI performs in Phoenix because they perform in the summer, and I just think Phoenix is inhospitable to human life in the summer. I can't imagine putting on this type of field show in Phoenix heat in July. I don't even know if that would be safe for the performers. But DCI.org has it, and then we will talk more about flow marching. We worked with Flow Marching last year. We are working to have a discount for you guys with Flow Marching. So that if you want to watch DCI, you can stream it from home on Flow Marching. So we are working on that for you. So you guys will have some options for watching from home. I love a couch tour. I love a couch tour. Love a couch tour. So we will have some options for you guys if you are interested in that. The South Carolina Supreme Court has not ruled yet. There are many that are saying that they have heard that the Supreme Court is going to overturn Justice Toll's ruling. Here's what happened. Justice Toll denied the motion for new trial. So what the Supreme Court can do is two things. One, they can overturn Justice Toll's ruling and send it back down to the lower court to be re-reviewed under a new standard, meaning they would essentially tell the lower court, hey, that standard's wrong. Make a new finding on the motion for new trial. But they also had a fresh motion with regard to the amount of financial crimes evidence that came in at trial. So could the Supreme Court just say new trial, yes? Maybe. I think it's more likely that if they set a new standard, they will overturn Justice Toll's ruling and send it back down for another ruling, finding then that he gets a new trial. So I think it will probably be a two-step process, but maybe not. It will just depend on how they address it because there are two different appeals going on. The one about the financial information and the one about Courthouse Becky. We're just going to have to wait and see what they do. Also, they drop things on Wednesday. We'll see. I have been keeping an eye every Wednesday to see what the South Carolina Supreme Court is doing. Tomorrow we're doing a sentencing. So tomorrow they are doing a sentencing or we are doing a sentencing, and that's what we're doing. If they drop that tomorrow, I'm not going to cover it while we're in the middle of a sentencing. We're going to be in sentencing and then we'll cover it afterwards. Not after the sentencing, but we'll cover it later. Well, so we'll just see. But they've had it for months. We don't know when they're going to rule. They could do it tomorrow. They could do it next week. They could do it the week after. They could do it in July. I don't know when they go on break, but they could do it the week before they go on break and drop it at the end of May. Who knows what they're going to do? I don't follow the South Carolina Supreme Court all that closely. I don't know what their vibes are going to be on when they choose to drop that. So we'll see what they do. But no, I had seen some questions in the chat last week. It seems that a content creator had a very clickbaity title that said that it was getting overturned. That is not correct. So it is pending. We are waiting for the South Carolina Supreme Court to rule. I think it is likely that they will adopt a new standard for evaluating judicial interference from a state actor, and that will allow for a motion for new trial to be granted, and then he will get a new trial. I think that's what's going to happen. So we'll see, but I think it's likely that it will happen. But we're going to have to wait till the judge rules, and when they do, I'll tell you. We'll put it in the app. Law Nerds, it's always a pleasure being here with you. Today was a roller coaster. Today was a wild roller coaster. Wild roller coaster. I hear you. Mama of a Medic said that makes me so mad. I hear you. Look. What Courthouse Becky did outrages me as well. I also think that when state actors are bad actors, there should be significant recourse for that. And I think that if Murdaugh gets another trial, he'll get convicted again. But you cannot have a state actor doing what Courthouse Becky did. And I think Courthouse Becky should have been punished more strongly for it. I do not like that Courthouse Becky just got probation. I don't like it at all. Not my call, though. I think she should have been punished more strictly because you are abusing a position of trust and power. And if you are trying to manipulate the judicial system, you are striking at the heart of where things need to be fair and protected. And thinking that you have the right to manipulate that is egregious. And also, if there is ever a time that punishment should deter others, it is when punishing elected officials. Just do your job. You wanted to do this job, do your job. The other clerk of court that came in and testified, I stand the other clerk of court. The other clerk of court was great. The other clerk of court is like, there is no nonsense here. There will be no fuckery in my court. You feel like she's got it handled. It's protected. There's no bullshit. Courthouse Becky, the bullshit on bullshit on bullshit on more bullshit. Nope. No elected official to try to manipulate the system. I do not like it at all. So, I think it is going to undo this trial. Honestly, if the vibes are Courthouse Becky shouldn't have done what she did, I think that's indication that a new trial is warranted. I do. And we'll see what the court decides to do, because under the standard in South Carolina now, they are at the proper legal result. If South Carolina changes that standard to more match what the federal courts do, then his motion for new trial will get granted because of Becky's behavior. And then she will have to live with knowing that she has cost the people who elected her into office, her neighbors, a fuck ton of money. She has cost her county millions and additional time, effort, energy, and pain to the Murdaugh family and others. And to all of the families that are victims of Alec Murdaugh as well. She did that. So good luck going to the Piggly Wiggly without people saying meanness to you or giving you because that's pulling money right out of their pockets to pay for a whole nother trial. Because she was what? Swayed by the siren song of celebrity. Don't like it. Don't like it at all. Monica said, do we think she cares? I think Courthouse Becky very much cares about how people in her community perceive her. I do. And I think that she cares about that perception. Now, if she's able to convince herself that they're all wrong and they just don't understand, then maybe. But no, I think that fall from grace hurts her ego a bit. All right. Law Nerds, let's see what this poll says. Wow, we're close. Over 5,000 votes. 55% of you think Kouri will have something to say. 45% of you think that she doesn't. We're going to have to wait to find out tomorrow. Bring your Kleenex. Stay hydrated. Tomorrow, we have a sentencing. Law Nerds, thank you for being here. Thank you, Team Baker. Thank you to the mods. Thank you to our amazing, amazing merch designers over at Bright Ideas. They have continued to create incredible things for us. Law Nerds, don't worry. I have let y'all know. I've let them know how you feel about the pillows. Everybody's like, where are the pillows? The pillows were for decoration. They were Easter eggs. They weren't meant to be merch. And now all of you are like, maybe. That's on our list. We might do a special pre-order for those down the road. To see, because we've gotten a lot of feedback about those. So thank you. That was Warren's idea. I appreciate you guys. Thank you for being here. Thank you for being a Law Nerd. Take care of yourselves. Take care of each other. Tomorrow will be a bit tender. So I will keep you posted in the app. Opt in and opt out is best for you. And I will see you then. All right, Team Baker. Thank you guys. Bye. Thank you for joining me. Make sure you don't miss a live stream or any of the updates
We
on the
updated
cases
the music,
that you
you
care about
guys.
most with the Law Nerd app at lawnerdapp.com.
I love it so much too.
It's a free download on iOS and Android, so I
Wait
can
for
keep
it. Wait
you
for the drop.
in the loop. Because you never know when something's going to pop off. Thanks for being here, and thanks for being a Law Nerd.